May please. With regard to item 19 of the supplementary list, in fact, my lord, pursuant to the court's direction, certain instructions are forthcoming, my lord. I have informed the other side also, and I need to put it on record. Can it be next week, my lord?
Item 19.
19, my lord.
Had a request made by Mr. H.K. Talukdar, Council for Cooperation.
Yes, my lord. In fact, the name is not reflected. That may be reflected in.
Department. Papered. It is listed listed next week on a date fixed by the next week. Council for Petitioner, I mean, Begum.
My lord, the name of the Standing Council
Name
Corporation.
of all councils, including
SC Corporation.
they reflected in the policies by the next week.
Obligation.
Yesterday we have filed an high. But even matter there is the interim order operating and the authorities are violating that interim order. So there is some urgency. I am praying for lifting of the high day after tomorrow.
Let it be on Friday or day after tomorrow,
Yes.
Thursday.
Yes. Deep level.
Wait, please, Lordship. Lordship, I'm praying for listing of this matter next week, Lordship. It hasn't been listed for a very long time, last year.
Which date? Which date?
Lordship, on 14th.
14.
On 4th.
All right, 14.
May it please, my prayer for listing of motion matter. Two motion matters for Thursday.
Friday?
My lord, two matters are
Friday.
right.
May I please,
These are fresh matters or new?
Fresh matter.
Fresh matter. Right.
May I please, Lordship? Matter, I beg to mention for listing and WPC on Friday. Can it be allowed?
What for? What purpose?
For the, I have been terminated in the last
Is
5
it for motion,
Motion
admission,
matter.
orders,
motion matter.
motion, new matter,
Yes, ma'am.
fresh matter?
Yes, ma'am.
My lord, for motion, my lord, may be listed on 9th, my lord.
Friday.
And these two matters for admission, my lord.
Admission on some other date.
Next Monday, my lord.
My lord, with the consent of the others, that I beg to mention item number.
1 minute. Motion on Friday, admission next week, 14.
I beg to mention item number 8. Can it be taken up after 2 weeks, my lord? In the meantime, I will file my affidavit in reply, my lord. Item number.
Date may kindly be fixed.
Item 8, that the
Item
request
8.
made by the council for the petitioner. Matter stand paper, we listed after 1 week. Council.
The respondent number 5.
MTV appears for respondent number 5.
5.
You want how much time?
After 2 weeks, my lord.
2 weeks. It had to be listed again on 27
My lord.
May.
My lord, that is an interim order, my lord.
Interim order, if any, will continue till the next date.
Obligement.
May it please, Your Lordship, I beg to mention for listing of IA for deletion of the name of the Comptroller and Auditor General of India on Friday, Lordship.
Friday, all right.
Obliged, Lordship.
May I please, Lord? We are praying for listing of motion matter. Can it be on Friday, my lord?
Fresh matter.
Fresh, my lord. Yes. Obliged.
with the consent of others, I beg to
Well, earlier it was withdrawn, my lord. Sorry.
Huh?
Earlier it was withdrawn with liberty afresh.
All right, but it is a
Lordship.
freshly filed.
My lord, yes. Obliged.
I beg to mention item 14, Lord, with the consent of the other side. I put a response of the Olida Limited. So in this case, we are led by Learned Senior Counsel S. Dr. Lordship. He is up of station. Lordship may have it on 15, Lordship.
15.
15, Lord.
It's a date like that. 15, then it goes to June. You are for the
Respondent Oil India Limited.
Who is for the
I'm
petitioner?
for the petition, my lordship.
Yes, what do you say?
My lordship, On 15th, your lordship.
It's a hearing matter. Why is it not listed in the part 2 hearing list? It will be listed in part 2 hearing.
My lord, it was from part 2, it came to the daily list.
No, let it go to the part 2 list.
Lordship, let it,
Matter be listed for hearing in the month of June.
lordship, we can do it today, your lordship.
Huh?
We will do it today, our part, lordship. They can do it later.
It will be listed in June in the part 2 hearing list. You make a mention when in part 2 hearing list,
Okay.
you can make a mention. We can accommodate your difficulties on a day-to-day basis. But if it is in a part 1 list, it goes out of the list, it has to be brought into the list, it causes some problem. Right. Part 2.
May I please, Lord? Lordship, I beg to mention for listing a WPC matter on for admission on Monday.
12, you'll have to come alone.
14th and
16. 16.
March. Okay.
May I please your lordship? I beg to mention item number 15. Lordship, we want to file an additional affidavit to annex some important
We
documents.
mean,
Sir, lordship,
we means
the petitioner.
petition.
Yes, lordship.
And for the respondent,
What do you say?
we're seeking adjournment today. We're seeking adjournment today, Lord.
You want to file additional affidavit.
Lordship, the other side counsel is also on leave. After 10 June, he will be available.
You file it, you make a mention, we'll see after that. Matter will deferred to be listed after 2 weeks on the request made by the counsel for the petition. Counsel to respondent is also present.
May I please, my lord? My lord, I beg to mention item number 4, ma'am. I'm praying for adjournment of this matter, my lord. Can it be listed after 3 weeks?
Why?
My lord, there is subsequent development that has taken place.
Item 4,
Item-
deferred to be listed after 3 weeks at the request made by the counsel.
Yes,
Sir, can it be 2 weeks? Because they are enjoying an interim order, my lord. We have got a health
my
order.
lord, actually, we are just challenging the transfer order.
Why do you want an adjournment?
My lord, actually, what has happened is like the transfer which was given to me was pursuant to the promotion that I has got. But what I have done right now, what I have come to know, the petitioner is saying that I don't want promotion anymore. Now, in that case, my application has been pending. Now, if any result come within these 3 weeks, we want to bring that on record by way of an affidavit. That is the prayer, my lord.
Application file for let it be after 2 weeks, let's see, because to my information, no application.
Matter sought for adjournment by the petitioner for the request of Mr. D.P. Bora, Committee Health. I will object submitting that that there is an interim order in favor of the petitioner, staying his transfer.
Yes, no problem. Not staying distance, but status quo order, my lord.
Status quo order in favor of the writ. He therefore submit that the matter be listed after. Considering the submission of the counsel before the party to the court, and considering the fact that there is a status quo matter deferred to be listed after.
My lord, but the status quo that Learned Council is referring to, there is an IA that the status quo order was actually we are asking for the intervention of this court because the status quo order was there. Despite the status quo order, I'm not able to enjoy the position that.
Actually, my lord, before the status
If you
quo,
want to do it, we'll take it up.
My
Wait
lord,
for
then
it. Item number 4, we'll call it up.
My lord, then after 2 weeks, then. Yes,
oblige, my
I'm
lord.
of
May I please? I beg to mention item number 2. In this case, my lord, if the respondent has filed affidavit in opposition of it, we need to file a reply affidavit. So 2 weeks time may be.
Item 2, at the request made by the counsel for the petitioner, stands enabling the petitioner to file reply affidavit.
Yes, sir.
The affidavit filed by the respondent.
Hello.
Yes.
May I please the Lordship? Lordship, a order was passed by this honorable court. Lordship will find it at page number 76, madam. May I read it, madam? The order. The writ petitioner herein was working as a technical expert in the fisheries department during the period 1/8/2018 to 31st 1/2025. From 18 to 2025, Section number 6 had issued an advertisement notice for recruitment of 65 numbers of fisheries development officers. The writ petitioner is qualified to apply for the said post. However, in view of the upper age limit of 38 years as on 1/1/2025, fixed by the advertisement, the petitioner's application submitted online was rejected on account of the fact that he was 42 years, 5 months, 26 days as on 1/1/2025. The petitioner had submitted a representation dated 6/3/2025 before the additional secretary, Government of Assam, seeking relaxation, condonation of his upper age limit as to enable him to participate in the recruitment process. However, since no action has been taken on the said representation till date, hence the writ petition. By referring to Rule 25, the Assam Fisheries and Aquaculture Service Rule 2024, Mr. Das had submitted here is a provision for relaxation of the age, and therefore there was no justification for the authorities not to consider the representation submitted by the petitioner. Mr. So, Provincial Council has confirmed that the representation submitted by the petitioner has not been disposed of. Since there is
Then thereafter it was disposed of.
since this court has observed, since there is a provision of Rule 2024 of relaxation of the
It is
operation
not
of the
observed. It is not observed. It is merely recorded.
recorded, madam. Recorded, madam. Now, madam, what happened, madam, after this, madam, they have passed an impugn order. They have Lordship will find it page 83. Page 84, para 8. Thus, in the instance case, and after careful consideration of all documents and text, the request of so and so for relaxation of the upper age limit is hereby rejected.
Where is the OM? OM?
Lordship, after that,
No, you are challenging this. Page 83.
Page 83, madam.
What is this?
Lordship, last date, Lordship, that order was passed actually it was oversight by us without considering the service rule, Lordship. Now we have passed in the last order, there only go to the last date order, Lordship.
They have recalled this order, madam.
We have recalled it and we have given this order. That order was passed without considering the service rule, Lordship. Earlier order.
Lordship will
I want to
get this time.
You bring it on record.
Okay.
You bring it on record.
By affidavit.
By whatever way. What is this that you pass one order and then you recall this
one
order,
after
pass
another.
another order?
What that is, madam, at serial number 9, madam. Sorry, madam. Of their this order, madam.
Well, I heard Mr. S.P. Das, learned counsel for the petitioner, Mr. Sharma.
P. Sharma.
P. Sharma, for the fishery. Pursuant to the earlier order dated 2/5/2025, the Standing Council Fisheries Department has placed before this court an order dated 5/5/2025, whereby the earlier order passed by the department in the present petition being order dated 3/0/2025 was stood amended.
Modified, madam. Modified.
That's modified. Mr. Sharma has placed a copy of his order before the court. Let this subsequent order be brought on record by the respondent within 1 week.
Madam, some protection, my lord. But because this is already over, my lord. This is the second petition, my lord. I filed.
No.
My-
What protection you want?
My prayer is
Ah.
to allowing me to participate in the recruitment process.
What recruitment process?
To the post of fishery development officer, my lord.
That's over, no? Over, no?
No, that protection can be given because your age correction will have to be done first.
Yes, ma'am, that will be done. But in the
Whether
meantime,
there
they
is a
should not.
provision, whether there is any provision or no
Yes,
provision.
my lord, there is a provision, my lord. Page 67, my lord. They are saying that there is no way now. OM is not required, my lord. The rule is here. Ma'am, page 67, my lord. Relaxation, my lord. Rule 25.
The petitioner is challenging petitioner is seeking orders from the court permitting him to participate in the selection process for
the post of fishery development officer.
For the post of fisheries development officer. As fisheries development officer, stock petitioner is presently serving as.
Now I'm not serving, my lord. I've been ousted, my lord, before this publication, my lord.
He's not an
employee.
Not now, my lord.
Not an
I
employee.
work for 8 years, my lord.
He's not, he's a friend. He's
Just
a
one
direct
prior,
recruitment-
my lord. I have been
direct
terminated, my
recruitment.
lord.
Development officer on the selection process undertaken by the APS.
But annex of 4, my lord, page 26.
In the event this court comes to finding that the petitioner's rejection was incorrectly made by the authorities concerned, consequential orders will be passed by this after 2 weeks.
Highly appreciated. My all motion, my lord.
Lordship may be personal department is also there.
So you first bring it on record. You have already brought it on record.
Yes, Lordship, I will brought in
Bring it
on
on record. You have it on 20. Third.
My lord.
Highly appreciated.
On motion, my lord.
Motion.
Highly
May it please your lordship. Well, I am a forest ranger presently in the Dhemaji division. My lord. What happened was I was caught by a captain on allegation of bribe, and thereafter departmental proceedings ensued. Now, when the proceedings were going on, I made specific allegations and requests that the cumulative effect of non-arraying of the trap members and not allowing me to cross-examine others would vitiate the statutory rules. And thereafter, we had approached this honorable court by writ petition 5396 of 24, and the honorable court's order is at page 44.
Yes.
45 it starts. May I read that? Counsel for the petition has argued that the departmental proceeding initiated against his client has been conducted in violation of the procedural safeguards as well as the principles of natural justice, inasmuch as his client has not even been allowed to cross-examine the witnesses relied upon by the department to prove the charge brought against by the petitioner. So D. Gogoi, understanding counsel for the department, however, submits that since the departmental proceeding is yet to be concluded, at this stage, it will always be open for the petitioner to agitate his grievance before the authorities. After going through the materials on record and after hearing the submission of the learned counsel for the parties, this court is also of the opinion that at this stage, no interference in the departmental proceeding is called for. The grievance expressed by the petitioner can be raised before the inquiry officer. In the event such grievance is not redressed in accordance with law, the matter can always be examined by the court as and when the occasion arises. Therefore, by granting liberty to the petitioner to agitate his grievances before the inquiry officer, the writ petition stands closed. Thereafter, this is 25th of October.
You are challenging the inquiry report.
I say the inquiry report is not only backdated, my lord. I say there is no memo number indicated. Now, kindly see, my lord, I received this on 17th of April through WhatsApp at page 53, my lord. Lordship takes up page 53 for a moment. That is 4th of November 24. The inquiry officer writes to the government of Assam, which is never communicated to me, which has no memo number. But surprisingly, I received this on 17th of April, along with a communication at page 69. Which talks about a different story altogether. It does not even mention about the inquiry report.
Yes, Mr. Gogoi, get your instructions.
Pilots.
In the meantime, if the disciplinary authority concurs, my lord, then things will go against
Let
me.
him get instructed by 2-3 days time.
My lord. In the meantime, they will not proceed on this.
What is there to proceed?
If the inquiry report is accepted against me.
It is inquiry, we will pass orders.
Very well, my lord.
We'll
Promotion.
Mr. S. Boniclan. For the Forest Department, it is agreed by the inquiry report. Submitted. Inquiry proceedings as well as the report.
Both.
And, initiated against the report. It is submitted that during the inquiry proceeding, he was not allowed to cross-examine.
Cross-examine?
Witnesses of the department.
And trap team members were also not the witnesses.
Eh?
Trap team members, all the trap team members were not added as the witnesses. After the direction
All
of
the
the
what members
trap team members, it was a trap team, my lord.
also submitted that the allegation against the petitioner is that the boss accepting a bribe. And however, all the members of the trap team reports were not produced at the witnesses. He further submitted that the inquiry report was not served on him, save and except a WhatsApp message
That also on the 17th of April.
on 17th April.
And my lord may also kindly refer to that communication at page 69. It has a bearing, my lord.
He also submits that department's communication with reference number CF number 225361 /282 dated 2/1/2024.
Also serves through WhatsApp on 17th.
Dated to have been served on the has not been received by the petitioner. You have not received that.
No, and it refers to something of 2nd of January 24. November 24 is the inquiry report, which is absolutely backdated. It refers to January 2024. No way connected here in Milos.
No, your letter at page 70 says you have not received something.
No, yes, 70 I said I have not received, but still I'll respond whatever I can. And 69 document refers to something way back.
Such circumstance, he has received the inquiry proceeding and the report and seeks good adequate protection of the report to the extent that disciplinary authority may not proceed further on the inquiry report. Mr. T. Gogoi, Forest Department permitted to complete instruction with regard to the attention raised by the prayer for interim will be considered on the next days. If not, 14.
Well,
Since he's there, in the meantime, he will.
14th of May. A bit later, my lord.
Then we some protection.
We are considering interim prayer, therefore.
Then 14 months preliminary instruction I can get back with it.
As to whether it is
My lord.
served, not served, what steps that you taken.
My lord.
14.
14.
May I break for a observation, Miller, if Lordship permits, Miller, that the communication by which the inquiry report was forwarded has no memo number marking whatsoever. It's required by the government
It
of
is
Assam.
submitted by the council for the that the communication by which the
Inquiry report at page 53, 4th November 24.
did not contain any memo number.
Absolutely.
As is necessary in all official correspondence.
My lordship. Obliged.
This 14.
Wait.
Interim prayer will be considered on the next day.
May I plead your lordship?
Yes.
The petitioner who were applied for the Anganwadi worker and helper in the according to the advertisement dated 5/11/22 for the 19 post. The advertisement was issued for the 19 post on different Anganwadi center, but that advertisement later on was cancelled and a fresh advertisement was issued on 29 September 2023. This time the advertisement was issued for the 29 post, my lord. And that was annexure, type copy is annexure 4 and page 34. And petitioner applied for the state post and for the 29 vacant posts of different Anganwadi center. And the final merit list was published, my lord. and the final list was published. That was start from my lord, from page 38, my lord. The petitioner in this final merit list, whose remark is where the petitioner serial number 4, my lord, where petitioner obtained 37% highest percentage among OBC and very efficient, and the serial number 7 obtained 40.60% very efficient candidate, and petitioner number 1 and 2 also very efficient candidate, and 2 also candidate is very efficient and from the AWC survey area, and all the petitioner was then appeared in the final merit list. Thereafter, my lord, what happened, my lord?
They are already working
They are already working, my
as
lord.
helper,
As Anganwadi worker and helper, some of the
helper.
helper.
And this
And
appointment is, this advertisement is for what purpose?
earlier they were appointed in the according to the advertisement, but subsequently that Anganwadi center was closed for some period of time. Again, this Anganwadi center was reopened and the post is re-advertised. And thereafter, my lord, a high-level council level empowered committee was held on 7/9/2024. That is Annexure 8, page 51, and where it was recommended that from the serial number 3, those who are not got approval, they may be recommended for re-interview. But that was not done. Thereby, the government respondent authority published a notification whereby the some of the
Will issue notice at this stage?
no, at least thereafter, my lord, another advertisement was issued on 2024, my lord. This time the advertisement was issued for the 90 post, my lord. And from the
What we want to know is, in the page, you are reading from page 38, no?
yes,
So these remarks of the selection committee,
yes,
this very efficient candidate, they have given it on what basis? You are working.
they are working and they are educational qualification.
But if they are working, then
No, those earlier they are working, and that Anganwadi center was closed. And again, when it was
so
reopened,
this report is in respect of the work which were done earlier.
earlier, my lord.
Earlier.
The report was done according to the earlier performance, my lord.
Yeah,
And
what-
thereafter, what happened? Again, the post was advertised on 2024. This time for the 90 posts existing with those posts, my lord. So today they will publish the final merit list. If the final merit list is published today, they are, I mean, definitely they are not appointing from the 23 according to
How
the
do you know that? How do you know?
petitioner has informed me that today they are going to publish the
No. Your petitioner's names will not be there in the merit list. How do you know that?
So this time they are applied, but there are 90 post, my lord, and definitely the day by day the marks obtained in the higher secondary level is increasing. So
That is not a ground. The
those,
if they are agreed by the method of selection, or if there is any
yes, my
mileage,
lord, agree by the selection because they are the person. Lordship kindly come to the page 38, my lord, 38, where the serial number 6. He obtained only 38.20%, but he got appointment. 38, my lord. He got appointment. And the serial number 3, he only 32%. He got appointment. And but the 2 got about 43%. She did not get any approval from the authority. So
no, we are not asking on. You don't want the merit list to be published.
yes,
Why?
but the merit list may be published, my lord. But this after if the merit list is published, my lord, the respondent authority is going to appoint from
That's
that
right.
merit
So
list.
your claim will arise only when the merit list is published. If your name is not there, then you can claim that you should have been selected.
No, my lord, this time, although the similarly situated candidate were obtaining less marks to the than the petitioner, then they got appointment.
Where are the marks?
Yes, my lord. The statement from the final merit list, it was indicated, my lord. The test 38 to 39. that petitioner number 1, that is Pushpa Roy, she obtained 34 marks. But she was very efficient remark, but she was not selected for the post. But petitioner number 2, she obtained 43%. But she was not, her name was not approved.
This is the earlier.
Earlier, my lord. So today they are going to appoint also the from this merit list.
Let us find out. Yes, Mr. Counsel.
At least, my lord, petitioner get appointment.
Let us hear him first.
Lordship, first of all, Lordship, may kindly turn over to page 34. From the advertisement of 29 September 2023, it appears that earlier there was a selection which was cancelled, and thereafter, Lordship, for the second time, advertisement was issued. The reference numbers and letters were given. Now, Lordship, the new
29 September 23.
Yes.
Advertisement. What happened after that?
Lordship, from the pleadings that has been made in the writ petition, it appears that the page 38, those were the selected candidates, and the posts were different. And in 2024, Lordship, that is at page 57. Here, Lordship, the posts are different.
Post are different, my lord, existing with the earlier post, my lord.
Lordship, if it has been merged with the new advertisement, Lordship, this advertisement was issued on 11 December 2024. Why the petitioner was waiting for such a long period? For almost 4 months has elapsed in 2025, Lordship.
The appointment was made only on the first week of January 2025, my lord.
That shows that 23 advertisement, on the basis of the 23 advertisement, the petitioners are working. Lordship.
But the minus of the state level committee recommended for the re-interview, but that was not done. But without re-interview, they are again publish another advertisement, my lord, without considering the case
No,
of
but
the.
is it in respect of your center?
Yes, my lord.
Where are your centers?
Center is.
Page number?
Yes. Page number 54, my lord. First one is Pitagon.
No, 50. You are now concerned with the subsequent advertisement, 11 December.
Yes.
11 December is at page 57.
Page 57, my lord.
Yes. From there, you tell us which are the centers.
First, serial number 3, Dhupguri. Serial number 5. Serial number 7. Serial number 8. Serial number 8 and serial number 8. Serial number 23. Serial number 28. Serial number 28. Serial number 28. Yes, madam. For 8 people. At least, my lord, this advertisement, according to the advertisement dated 24.
You participated in the advertisement?
Yes, sir. I have
Selection process?
Yes.
Then, why do you apprehend that you will not be selected?
I've not been selected. If I selected, but they are going to, already they have twice, they have 2 times their name appear in the final merit list and they're on.
No, maybe, but in the advertisement of 2024, page number 57,
yes,
you did not challenge this advertisement. You participated.
Yes, my lord, participated as because our center was there, my
That's
lord.
right.
That
You
is right.
participated.
Yes, my lord.
Now you can challenge the selection process only when the results are declared.
Candidate is increasing, my lord. For one center,
Maybe, but you participated, madam.
yes, my lord. But earlier there is 2-3 candidates. But this
That
time there
can't be.
may be
What can the
percentage.
court do about it? The competition will increase.
Maybe, my lord. if their name was appeared in the final merit list in according to the advertisement of 2023, and some of the candidates were already appointed who obtained a less percentage, my lord.
Quite right. But today, that advertisement was in 23. You were selected, you were not appointed. Subsequent advertisement in 24. You participated. Now you are challenging what in 25?
My prayer is that I am praying for the appointment to be made according to the final merit list which was published according to the advertisement dated 23, my lord. And secondly, my lord, the minutes which were
That
recommended.
advertisement, that
Secondly,
appointment
the
has
minutes.
already been made.
The-
Those appointments have already been made.
Itself is a difficult, the advertisement was issued without considering the state level committee minus.
Then you should have challenged this selection process. You should have challenged the selection process of 24. 24 selection process was advertised on December 2024.
That was, the final merit list was not published.
May not be, but you participated.
Yes, ma'am.
Then yes, get instructions.
Some consideration may be given because the my lord, they are already 2 times they are appeared and.
Let him get instructions. We'll fix it on 16th February.
But today,
May.
16th of this month.
Heard? Is it PTC?
Yes, my lord.
The rate Chakraborty for?
State respondent, Lordship. Commissioner and Secretary, Lordship, one respondent, 1 and 3, Lord.
Respondent. Petitioner brief that although their names had appeared in the final selection list for appointment posts of Angatwadi worker / Angatwadi helper in their respective centers, pursuant to the advertisement dated 29th of September 2023, they were not appointed, although persons having scoring lesser marks than the petitioner were appointed. It's further submitted that left with no option, the petitioner that participated in a subsequent advertisement dated 11 December 2024 with the hope that they would be considered for the post, state post. The counsel for the petitioner admits that there is an apprehension that the petitioners will not be selected even in this particular advertisement, and therefore has approached this court praying for appropriate direction or order. They submitted that the final merit list is likely to be a final merit list in respect of the selection process undertaken pursuant to advertisement dated 11 December 2024 likely to be taken up, likely to be published within this week. So, we therefore pray for adequate attention. Mr. B. Chaudhary, no instructor would like to let the matter be listed again on 16th of May. 16th of May. Any selection made pursuant to the advertisement dated 11 December 2024 in respect of the Anganwadi sectors which the petitioners claim will be subject to further orders from this court based on 16. Although notice is not issued, in order to enable the standing counsel to obtain required instructions, extra copies will be furnished within the course of the day.
Yeah.
This recording.
Yeah, please, ma'am.
Yeah.
Now, the petitioner hearing is serving as a doctor in the BSF.
when she was informed in the month of December 2024 that she would be considered, she would be under the zone of consideration for transfer, at page 21 was an application she had put in. What happened is, my lord, her daughter was then in 2024 in the class 9, was registered with the ICSE board, which registration is not transferable. Therefore, at page 21, Lordship will find the application which was given that my husband doesn't stay with me, he's in Shillong. So I request a retention for a year so that my daughter can complete her education here. 24th of March at page 23, madam, she was put into transfer, the first person, from CH Patgaon to Composite Hospital, Agartala. The date of relief, Lordship will find it page 24, was to come by 30th of April. Immediately thereafter, she moved a representation on 26th of March at page 25. And Lordship will find at page 20 is the certificate from the school that the registration is non-transferable. Page 26, Lordship has for a moment. The second paragraph. Page 26. She has been registered for ICSE 2026 board exam from Sanskrita Gurukul, and according to the ICSE norms, registration once done cannot be changed. At page 27, Lordship will find all the school fees and everything was paid on the 19th of February and 8th of March, much prior to the transfer order being issued, and her application till then not considered. On 30th of April at page 29, Lordship will find a movement order was issued to her. Clause 11, Lordship will find the last line at page 29. Officer has been struck of strength of CHBSF Bottom on 1/5/2025. On the 1st of May, she would be struck of the strength. On page 30, she was forced to give her relinquishment of charge on the 30th of April itself. And just prior to that, she was handed over page 31, which is dated 29th of March, saying that at serial number 1, just the paragraph above, could not be acceded by the competent authority. Her request for retention for a year was not considered. On being informed as such, at page 32, Lordship will find I gave an application to avail childcare leave for 365 days so that I can stay with my daughter here.
Does it preempt any transfers on childcare leave?
My lord, what has happened? This honorable court has few decisions have brought. When a person applies for childcare leave on the ground of transfer or to take care of the child, even under transfer, first the childcare leave has to be allowed or considered. Thereafter, her posting to some other, her reporting at the place of transfer is to be considered. I have those judgments with me. Then Lordship will kindly find at page 38, the posting policy of doctors in the Central Armed Police Forces. Here, Lordship will find at page 39 onwards, all other things given at page 40, the competent authority, how to do the posting, everything given. Para 12 at page 41, Lordship will find. Representations, if any, against transfer order which must reach the competent authority through proper channel within a fortnight of transfer order by the quickest possible mean, which will be considered and disposed of within 15 days from the date of receipt. However, transfers on promotion or administrative so can be considered by the competent authority as and when required, so independent of the annual transfer. In the entire policy, what are the grounds on which a representation can be made, or what are the considerations to be taken into have not been given?
Your ground for representation is childcare leave.
Either of the two, madam. If I am given a retention here, I keep serving in the hospital, I take care of my child. They avail my services. If that cannot be possible, then my right to a childcare leave has to be considered before I go and join somewhere else.
It's not possible, therefore they are transferring you.
Then my childcare leave has to be first taken care of.
For the rules that childcare leave has to be decided prior to any orders to transfer, etc.
First of all, madam, I'll just put in the Supreme Court judgment on childcare leave. What is the right of the petitioner to avail childcare? Lordships kindly have para 7. The participation of women in the workforce is not a matter of privilege, but a constitutional entitlement protected by Article 14, 15, and 21 of the Constitution, besides Article 19(1)(g). The state as a model employer cannot be oblivious to the special concerns which arise in case of women who are part of the workforce. The provision of childcare leave to women subserves the significant constitutional object of ensuring that women are not deprived of their due participation as members of the workforce. Otherwise, in the absence of a provision for the grant of childcare leave, a mother may well be constrained to leave the workforce. This consideration applies as a fortiori in the case of a mother who has a child with special needs. Such a case is exemplified in the case of the petitioner herself. We are conscious of the fact that the petition does trench on certain aspects of policy equally. The policies of the states have to be consistent and must be synchronized with constitutional protection and safeguards.
How many days are you given childcare leave?
730 in my entire career.
730
days. 2 years leave. Yes, 2 years leave. And para 13 lordship will have. In the meantime, pending further orders, the application by the petitioner for the grant of childcare leave, special leave under Rule 32 of the CCS, shall be favorably considered by the competent authorities. Another judgment, my lord, from this honorable
Your
court.
CCS rules are applicable.
Yes, my lord, for leave I mean. This lordship will have is another judgment by this honorable court. In 2023, lordships may have para 8 onwards. This was from the CRPF. In the instant case, the petitioner herein has 2 children, one who is presently pursuing her studies in the 8th standard and the other child is 3rd standard. The husband of the petitioner is presently posted at 133 Battalion, which is left-wing extremist area. These aspects of the matter are therefore required to be taken note of while exercising the discretion by the authority concerned. Court has also taken note of that on 8/6/23, the petitioner has submitted a leave application. Para 9. This court therefore is of the opinion that the interest of justice will be met, that an opportunity be granted to the authority concerned to take a call on the application so filed on 8/6 by exercising the discretion, taking into account relevant factors which have been mentioned here and above. Accordingly, this court disposes of the writ petition, directing the respondent to decide the application dated 8/6 filed by the petitioner within a period of 15 days from the date of the instant order. Till such time the application is decided, the petitioner may not be relieved from the group center CRPF Guwahati. In this case, they got a relinquishment signed on first, therefore, I'm not praying for non-relief. Another order that I'm placing.
Yes. What do you say?
CRPF.
Respondent.
Lordship will just allow me one more situation. Just one more situation. In this Aloka Basumatari case, Lordship will find at page 8, para 9, where the application was still then not submitted, but at para 9, Honorable Court says, in the event any representation is submitted by the petitioner within a week from today.
That is precisely what we don't want to give you.
My lord.
This is precisely what we don't want to give you. Retention in your place of posting till disposal of representation.
No, my lord.
Not what we want
No,
to give you.
I'm not joining there till they dispose my representation. I'm already relinquished.
How does it help your argument?
I don't mind. I don't leave my children here. I go and join. Whom do I leave my children with, my lord?
Disposal of representation
My lord.
is not going to be for 2 years. I mean, you're not going to get a time for 2 years. You are urging your case that you have a right prescribed under a statute towards child care leave. And if you have applied for it, what is the responsibility of the authority in redressing that?
That is what I.
That's all. Or would you be satisfied with the disposal?
No, I'm not satisfied with the disposal. My lord. They retain me or grant me the leave. Either of the two.
This childcare leave application is of 34 only when a movement order has been issued, Lordship.
Whatever it may be.
But firstly, she wants the extension of 1 year on the ground of her daughter is studying in class
The whole
10.
issue that therefore the child care leave. Therefore the child care leave. And it's a leave prescribed under a statute.
That is there,
How
but
do you deal with it?
but when application must have been given at the time also, but when her prayer for extension was
The
lodged.
necessity will arise only on a given set of circumstances. Once she's here, she's working, doesn't hamper her responsibilities towards giving care It is but when there's a transfer, the grounds which they have heard here, perhaps factually correct or not correct, we don't know it.
Yes.
But only then the question of leave is there. An employee has different kinds of leave: casual leave, earned leave, paid leave, no pay leave, half pay leave, and there's childcare leave also.
Lordship.
So you get your instructions here, and till then don't enforce the order. When can you get it?
14 or 16? 16, Lordship.
16. All right. Heard Mr. R. Madhukar and MS P. Sharma, the Commissioner before this court, he is employed as an anesthetist. He's an anesthetist in the Composite Hospital, BSF, Patna. She is sought to be transferred by which order?
Order
29.
29th,
Page number 29.
but 23. Order is dated 24/3/25.
Order dated 24/3/2025. She has been transferred from Patna to Agartala. Her movement order was released on 30 April, and she has been struck for strength from the Composite Hospital BSF Patna with effect from March 5, 2025. The petitioner submits that presently her daughter
Two daughters.
are students, are school-going children, and one of her daughters
Elder daughter.
Appearing for class 10 boards.
Class 10 boards.
When?
2026.
2026. And therefore, at this stage, our movement from Guwahati to Agartala would be detrimental to the scholastic pursuit of our children, especially the elder child. Therefore, represented before the authority praying for child care leave by where is the representation?
That is at page 29, 20, page 32.
Representation dated 34 and 35.
34.
34.
34.
So this that I is submitted by the council that child care leave, when applied for, is to be effectively considered by the authority. However, the movement order was without considering the child care leave application furnished by the council has referred to orders passed by coordinate basis as well as the support of MSP Sharma, on the other hand, that she would like to obtain her expert. That are considering the submissions made and also the fact that child care leave is specified under 68 rules. 68 rule number
43.
is incumbent on the authority to decide the representative and pass the effective order. Looking into the hardship expressed by the petitioner and thereafter pass the effective order representation. Let the matter be listed again on 16th of May, by which day that CTC will obtain a required. If the takes 8 weeks, the movement order cannot be enforced. Respect of the different. But if you're struck of strength, You're not going.
No, what I can
You're
do
not
is,
getting your salary from Patgaon.
no, I have to report here to say that I am not off duty. I do not run away, that I am not off my job. I report there every day. They give me work, I'll do.
Unless you're brought back into strike,
My lord.
your salary will not come
Not-
from here.
yeah.
You still have to go to Agartala.
In case, my lord, the disposal of the writ petition, it will be there,
Direct.
how to. As of now, my lord, I'll say. In fact, my lord, one aspect she may also like to clarify.
Don't end up becoming Abhimanyu.
Something I can't come out of.
Yes.
Obliged.
You furnish extra copies. Yes, within the course of the day.
That is, SSL was supposed to file an affidavit. We've just received the vetted copy today morning. Lordship will file it during the course of the day, and we've already informed the petitioner about it.
Only date may be fixed, my lord.
Give us your date.
As your lordship. Last week of May, my lord.
Last week of May. Then it has to be June. 2nd of June. And the
Tell you.
request comes made by the counsel for the respondent. And it is submitted that the objection / affidavit is likely to, it will be filed during the course of the day. It is recorded.
Thank you.
2025, no? They are taking time to file eligibility.
May I please, Your Lordship? Your Lordship, today we are going to file our affidavit.
Yes, Mr. Sharma.
Yes, yes. I must.
Mr. R.P. Sharma, existed by
Caretaker.
Sir,
Mr. S. Dekar, appearing on behalf of Mr. M. Sharma.
S. Dekha appears on behalf of Mr. M. Sharma for
Respond to
the
one picture.
respondent bank. Submit that. You'll file it today.
Today itself.
Submit the affidavit. Will be filed during the course of the day. Let the matter therefore be deferred to be listed after 2 weeks, enabling the petitioner to file reply affidavit if so inclined.
On my lord.
You file your reply if you want, then you
Yes,
make
I'll file.
then you make yes.
If you file within 2 weeks, I'll file.
28.
20, yes.
Obliged. It's not ready.
Well, Lordship, kindly pass over for a time being. ABT Hawk is in court number 1, Lordship is coming.
You're for the respondent petition. Item 5, yes.
Yes.
Pass over.
Yes, Lordship, for a time being. Is
And be.
Lordship, I have the attendance register, and her name is nowhere to be seen, Lordship.
You flag it?
Yes, Lordship.
My lord, my lord, in fact, my lord, their attendance register already perused. My name is not there. My lord, it was, my lord, directed
On the
earlier.
last date, you mentioned that all the attendance registers are to be produced.
From my lord, no, my lord, from 2006 to 2020, my lord, there is a order, my lord, that register has not been produced.
Is it produced?
No, my lord. Which order? My lord, you
Which
lordship
order?
kind,
Which order?
my lord, you lordship kindly peruse order
24/5.
22 2023, madam.
22
20th February, madam.
Yes.
My lord, you lordship kindly see last portion. Only 2 register were produced. Now, my lord, my learned friend has produced that 2 register, my lord. Last year, last paragraph, my lord. Taking into considering the said period for the which for the petitioner is claiming salary is from month of
March 2016, this court direct the health department to produce on next date the attendance register of the may I help you from the period of 2016 to 2020. My lord, that's two register already produced, my lord.
May I have a look at the order dated, the next date,
Yes,
27 to
27 to 2, my lord, you lordship
On
kindly.
that date, Lordship,
Your lordship kindly.
everything was considered.
My lord, your lordship kindly peruse. Only, my lord, November 2020 and till today, till date, my lord. My lord, earlier period has not been produced, my lord. That's why, my lord, that is my case, my lord.
Where are there any registers for the earlier
Lordship,
period?
today I have registers from November 2020 to
Already
November 2023.
That has already been perused.
Not
Prior to that,
Prior to that, Lordship, never has been produced.
never has been produced.
are they available or not?
Yes, Lordship, they are available.
So you bring it in terms of this order, 2016 to 20.
20 to 2023. Lordship.
2016
Yes,
to 2020.
22,
Lordship, that time
2023.
it was produced, Lordship.
No, my lord.
27 to 2023, it was produced
No,
and then
27 to it has the recording is that from November 2020 till date it has not, his name is not there.
No, not there.
We want to see from 2016 to November 2020. So November 2020 you don't need to bring. You bring it to 2016 to October 2020.
Lordship, if there is an order, Lordship, I'll get it.
This court by earlier order dated 2002-2023 directed production of attendance registers of within courts. May I help courts to for the period 2016 to 2020. 2020. Subsequently, in the order dated 27 to 2023, it is not clear whether the registers as directed for the entire period was produced to the court. What is recorded in the order is that the petitioner's name not seen in the attendance register from November 2020 till date. So, thereafter, matter has come up on several days. Were registers in the absence of any in however these registers were not predicted to the court. The standing council health is permitted 3 weeks time to produce.
Lordship, today I have produced, I have the.
No, you produce all of them
All.
together. All the attendance registers of the period. Which period you want?
My lord, 2016 to
Which month? Which month?
my lord,
March
March
2000.
March 2016 to
to 2020.
October 2020.
Yes,
2020. October or
My lord.
November?
October, Lordship, November I already have.
Or October,
October
my lord.
2020. So let this register be produced before the court after 3 weeks. The board appears for final.
Final, Lordship, respondent file.
Please take order.
Obliged, my lord. Highly obliged.
Later, affidavit in opposition has been filed. We are not inclined to file reply because the same thing reiterated. So may I pray that maybe date may be fixed for final disposal.
Okay, Lordship. Any month on, any
What are
day
you
on.
claiming? What are
My
you
lord,
claiming?
the small nutshell fact is that he was removed. He is the assistant working in the insurance company. He was removed from service. He approached this honorable court. An honorable court may set aside the removal order. Then they went to appeal. Appeal only modified that disagreement note only there. Thereafter, my lord, he was again he reinstated, but at the lowest stage of the scale of pay, that is the 1991, the scale of pay he joined. So that the order, my lord, in my humble submission is charge not commensurate with the charge. There are lots of things, my lord.
The record will be necessary.
Yes.
What is the?
We should issue rule, call for the record.
My lord, call then on 3rd of June, 4 weeks time will be prepared, my lord.
We have to call for the record.
Yes, they will produce the record.
Let us issue rule, matter should come up for hearing.
That he is part of retirement, my lord.
Can be helped.
That is what I am praying, my lord.
We'll try to include you with the list. Record production is different, but we'll have to call for the record.
My lord, that is date may be fixed, they will come with record.
All right. How much time?
Your Lordship, 3rd June is fine.
Again, on 3rd of June. 5 weeks late. The respondent will produce we'll keep the relevant records of the proceeding available, perusal of the court if required.
My
Item 9.
Yes, Mr. Hawk.
My lord, petitioner before your lordship, my lord, is here personal, my lord. Hey, my lord, is agreed, my lord, of not granting, my lord, the benefit of second MSCP, my lord. Although, my lord, he has been completed 20 years of service, my lord.
Why?
Now, my lord.
Downgrading.
My lord.
Is it because of downgrading?
No, because of not downgrading, my lord, they have interpreting that FR, my lord, annual performance assessment report, my lord, that they have filed their affidavit, they stated that it should be very good, my lord. But in fact, my lord, the very good is only 2017 onwards, my lord. Before that, my lord, it is good, my lord. Now, accordingly, although the petitioner fulfills that eligibility criteria, my lord, but his second MSB benefit has not been
Where
granted.
is the eligibility criteria?
My lord, kindly come to my lord page. Their affidavit in opposition, my lord. Page 105, my lord. You will find, my lord.
Yes.
Yeah, my lord. If your lordship can kindly come to page 104, my lord. At paragraph 17, my lord. Last paragraph. 17, my lord. Here. For a grant of financial upgradation under the MSCP scheme, the pay scale benchmark shall be very good for all levels. This shall be effective for upgradation of MSCP falling due on or after 25/7/2016, and the revised benchmark shall be applicable for the year 2016-17 and subsequent year. Now, my lord, kindly come to 17.2, my lord. While assessing the suitability of an employee for grant of MSCP, the departmental screening committee shall assess the efforts in the reckoning period. The benchmark for the efforts for the year 2016-17 and thereafter shall be very good. The benchmark for the year 2015-16 and earlier shall be continued to be as per the MSCP guideline issued by DOPT dated 17/5/2009. It is quoted, my lord. The financial obligation would be
Where is the order? Where is your order for rejection?
Well, there is no order, my lord. They have not passed any order, my lord. But that benefit was not granted. However, my lord,
What have they
had,
stated in their
yes,
affidavit?
my lord. Kindly come to page, my lord. This is the
Page 93, Lordship,
93.
this is a
Page
table of all the persons whose cases were considered. Page 93, serial number 30. This is of
Your lordship will find, my lord, is Pankaj Das, my lord, the present petitioner, my lord. Page
so we have given the reason also.
kindly come to, my lord, next, my lord, date from who is due for sanction of second MSCP with pay scale. Due for sanction of second MSCP with effect from 10/3/2017 in the pre-revised pay scale of 5,200 to 20,000. Well, it's get pay, well, it is important. Well, get pay 2,800, well, level 5. Now kindly come to, well, right side, well, ACR getting last 5 years. Here your lordship will find, well, for their 2013, well, petitioners.
You show us the requirements, where is the requirement, how many ACR gradings are necessary?
Well, they have found, they have constituted this list, my lord, and right side, my lord, remark, my lord.
Where are the rules? Scheme, where is the scheme?
Scheme lordship page 97, there is, we have also stated, and this is
95,
page 97,
97.
part 2.
No, this is the
Not
this is
recommended.
the decision.
Yes, lordship.
Where is the scheme? Where is the MSCP scheme? Is it available somewhere?
Scheme is not there, but this memorandum is clear, lordship, that 5 years, and that he had shown at page number 105. It is also there, lordship. Example is there. This is a OM, lordship. Starts from 102.
If 5 years ACR is necessary, where is it mentioned? Five years ACR.
That is the practice, lordship, and all were considered in the same way, lordship. But 5 years,
My lord, that scheme, my lord, your lord will find page 20, my lord, my description, my lord, and it is just from page 17, my lord. There is the office memorandum, my lord, of 2009, my lord, modified ACR career progression scheme, my lord, MSC, for the central government civilian employees, my lord. And your lordship will find the relevant portion on page 20, my lord. Modified ACR career progression scheme, my lord. There shall be 3 financial upgradation under the MSCPs counted from the direct entry grade 1 completion of 10, 20, and 30 years service respectively. Financial upgradation under the scheme will be admissible whenever a person has spent 10 years continuously in the same grade. My lord, who completed 10 years of service, he will given first MSCP benefit. Whoever completed 20 years, my lord, he will given the second MSCP. There instant case, my lord, the petitioner has already completed 20 years of service.
No, this benchmark of good, very good, where is it?
There is no mention. But they had, my lord, page 105, my lord, they had given an example, my lord. Kindly come to again, come to page 105, my lord.
105.
Yes, my lord, of their affidavit. My lord, here, my lord, that OM which I had earlier referred, my lord, that quoted from that, my lord. The financial upgradation would be non-functional basis subject to fitness in the hierarchy of grade of pay within the event one. Therefore, the upgradation under MSCP, the benchmark of good would be applicable till the gateway of rupees 6,000 in pay band 3. The benchmark will be very good for financial upgradation to the pay band rupees 7,600 and above. Here, my lord, Lordship has already gone to page 193, my lord. Here petitioners payment, my lord, only, my lord, 5,200, my lord. Payment 2,800, my lord. And very good is not applicable in the case of the petitioner, my lord. Even if it is considered, my lord. Ultimately, petitioner is eligible for second MSCP benefit, my lord.
This is your first or second?
Second MSCP.
Second.
The good and very good is their lordship office memorandums are there. Page 73, one and page 75, two office memorandum. Earlier it was good for page, in fact, page 74 lordship. Paragraph starts from paragraph 4 of my affidavit.
If you come to page 105,
Lordship.
it's a part of your affidavit.
Yes, this is also part of our record. So
it reflects that the benchmark of good would be applicable up to pay grade of 6,000.
up to 2015-16. After that, 2016-17, it should be very good for both. That is why the benchmark has been upgraded. Lordship, it is, for example,
This is altered by which OM? It's 19 OM.
no. It was there by this office 74, 75 OM.
It's 19 OM, my
75 OM. How could be 19?
It is 19 OM.
এখন তুমিহে দেখাইছা, মই দেখোৱা নাই।
I am putting it from your
Annexer, page 75. Prior to that, annexer A is also there. From 25/7/2016, the benchmark has been upgraded to very good.
And your period falls for which period? Period for MSCP?
My lord, 17, my
17.
my lord. Because my lord, petitioners joined on 8/8/1997, my lord.
Asking you on which date he joined. You know when he's
My lord,
claiming period for
2017, my lord.
2017.
My lord.
So if you come to page 75, the benchmark has been increased to very good.
Yes, only 17, my lord. 17 in this, for the year 17, my lord, my benchmark, my paper is very good, my
Not
lord.
for 17, you read page number 75.
My lord.
Read page 75.
Modified, yes, sir. Modified issued career progress system MSCB for the board has been receiving the number of references from various function of the session working certificate 25/7/2016 maybe apply very good. We will have 25/7/2017 maybe applied to MSCP of 2015-16 period to the whether the references should be given the opportunity to represent against the good getting in the HCL. Here, my lord, in this case, my lord, it is 2017 note, my lord, office memorandum, my lord. And this memorandum, my lord, there are several memorandum, my lord. And 105, my lord, it is a part of the office
Why
memorandum.
don't you read this 75 completely and tell us?
My lord, the matter has been examined in consultation with the DOPT, and the DOPT has opined that there is no question of allowing second opportunity of representative against the affair which are post 2009, as these are had already disclosed to the employees in the FR process. DOPT 5 OM dated 29 2016 has implemented the recommendation of 7 CPC accepted by the government for enhancing the benchmark for grant of MSCP to very good. These instructions are applicable with effect from 25/7/2016. The date of issue of government resolution by Department of Expenditure. Therefore, it in cases where the MSCP falls due on or after 2015, after 25/7/2016, the revised benchmark of very good is to be followed. In other words, the overall grading of the MSCP benchmark of grant of MSCP would would be at least very good. Yes, madam. Here, madam, it is published in the 2017, madam.
Maybe.
Kindly
But
come.
it is with effect from 25/7/2016.
madam. Kindly come to madam. That has been already explained in the page 105, madam. How these are calculated, madam. They have already quoted, madam. They have given the example, madam. It is the part of the office memorandum of 2019, madam. Sorry, 2000, 2019 office memorandum, madam. Well, kindly come to the above the table, madam. For example, if a particular MSCP falls due on or after 15/7/2016.
Fall under which level? 11 or 12?
Level 2, my lord.
Page number
GP
105.
page number 93, my lord, level 5 of pay matrix 29,200.
You are referring to page number 105.
Yes, my lord.
The chart.
Yes, my lord.
Fall under which level?
Well, the benchmark granting MSCP for level 11 and below. I'm below, my lord.
You're below.
Yes.
So it is 16, 17, very good.
Yes, yes. Well, good. 13, 14, good. It covers me. 15, 16, 14, 15 covers me. 15, 16 covers me. 16, 17, it's very good. 17, my ACR is very good. Kindly come to page 93, my lord. Moreover, my lord, these are the beneficial schemes.
No, beneficial, okay, but there has
93,
to
kindly
be.
come to page 93. Again, the petitioner kindly see, my lord. ACR getting list 5 years, my lord. Here, my lord, 2013 good, 2014 good, 2015 good, 2016 good, 2017 very good.
This particular page is not properly the copy. This. Do you have a better copy of page 93?
No, my lord, they have filed this, my lord.
Or you have filed it? One part is missing. Photocopy. The remarks follow.
Yes, Lordship. Not recommended for sanction of second MACP with effect from this 9/3/2017 due to
Not here.
benchmark Asia during 5 years. So that is the.
Do you have a copy of this? Better
No,
copy
I
of your
have
record?
no
Same copy.
record. I have, but this is not a part of the record, Lordship.
No, no, this particular page.
This particular page is not in the record. It's only a memorandum, Lordship. Even in
Will you get a copy?
second,
Is this
Lordship, 97 is same, Lordship.
97?
Yes, here it is clear. Serial number part 2, serial number 4.
No, this is what we trying to say. Even if you take your OM into consideration,
Lordship.
then is very good with effect from 16.
Yes, Lordship. 25/7/2016.
16.
Yes.
Now he is claiming up to 17.
Yes.
So from 16,
For 16, the problem is there because for 16 he is only good, but it will have an effect from 25/7/2016.
but then what do you say in respect to page 105?
That is, Lordship. 16, 13, 14. We have to count. He falls on 10/3/2017. So he 13, 14, 15, 16, 17. We have to count. So 2013-14 will be 13, 14-15 will be 14, 15-16, 16, 16-17 is for this 16 and 17-18 is for 17. Before 8, in that case, after 25/7/16, it should be very good. But he's
75 and 105. If you take this 75 is effective from 25/7/2016. So it will fall in 17. 1 for 1st April 17. 1st April 16 to 31st March 17. So if you come back to 105, 13, 14, 14, 15, 15, 16 is good. 16, 17 is very good. And how much has he got?
93. Thirteen good, 14 good, 15 good, 16 good, 17 very good.
page 104-17-1. This is clear that we have to take page 104, Lordship. We are not.
Yes.
Page 4, grant of financial upgradation under the MACP scheme. The prescribed benchmark shall be very good for all levels. This shall be effective for upgradation under MACP falling due on or after 25/7/16, and the revised benchmark shall be applicable for the APR for the years 16-17 and subsequent years. So 16-17 should be very good. But 16-17, will be 2016 only, because 2017-18 will be for 17. Otherwise, 2007 it will have to be from 2012-13. 5 years if we have to count like that, lot. Because he falls in 2000.
Only for 1 year.
Yes, 1 year. Others he is good. We will take it as very good because at that time benchmark is for good only.
For 16, you have to get good.
My lord, here in this case, my lord, the 75 page, my lord, it was given effect on the 25/7/2016, my lord. Ultimately, it now, my lord, the benchmark period, my lord, the quiz period they will count, my lord. Kindly come to if it is so, my lord, then in the page 93, my lord, they should have written, my lord, for the quiz 13, 14 good, 16 good, 17 very good, my lord. And payment also covers me, my lord.
No, pay ban covers you, but the revised scheme level 11 and below, you have to get very good for 16.
But that effect was given 25/7/2016, my lord.
Correct.
Ultimately, it will cover 17 also, my lord.
Will cover
So
17.
ultimately, that memorandum, my lord, that very good will affect it for the year 2017 only, my lord, not 16, my lord. Because, my lord, already
On
that was
what basis are you making that pay?
because, my lord, it was given effect 25/7/2016, my lord.
25/7/2016.
16, my lord. It was given effect, my lord.
Your ACR for 2016 will cover which period?
Now they will better known, my lord.
You are an
Because, my
employee.
lord, my understanding, my lord, very good understanding, my lord.
No. ACR for 2016 will cover from which period to which period?
my lord, they prepare the ACR, my lord. Ultimately, they will know, my lord.
You
which
have
period
to
they counts,
write
my
the
lord.
self-appraisal
Because, my
report.
lord, in the ACR getting 93 page, my lord.
You write your self-appraisal report.
No, my lord, they write, my lord.
There's no self-appraisal.
Annual performance appraisal report are prepared by the department, my lord. I cannot write my own ACR, my lord.
We're not asking you to write your ACR.
No,
We're
my
talking
lord, I'm
about
just,
self-appraisal.
my lord.
Yes. For which month?
Lordship, report for the year, Lordship page 84. I even have the original record also. Page 84, Lordship.
Yes.
So it is for 14 to 16 to 31/12/2016.
You'll have to segregate it.
25/7/16.
24/7.
25/7. Prior to that also, it's we have annexed all those. Previously one also is only good lordship. And if lordship compare the others conditions, so we have stated that what we have taken 13, 14, 15, 16, 17. So page 105 has to read like that 2013-14 is for 13, 14-15 is for 14, 15-16 is for 16, 16-17 is for 16. So maybe 6 months, 25/7, but after effect of that was not challenged by this before. In fact, his petition, his prayer is to upgrade his benchmark. That is only his prayer. He had not challenged those things, Lordship, that notification, etc. What is his prayer in the petition, Lordship? May see page 15, to grant the benefit of second MSCP to the petitioner by reviewing the grading of petitioner from good to very good in the APAR of the petitioner for the year 2016. So that is his prayer. So he wants that it should be upgraded. How could Honorable Court direct to upgrade Lordship? Because it is on the basis of his performance, Lordship. His prayer is to only to give him upgradation in his 2016. He also know that he had not received that benchmark. That is why this prayer.
See, here the period starts from 14/2 to 2014 to 2016. So from 14/2 to 24/7, benchmark of good is sufficient.
Lordship.
It is from 27 onwards, the benchmark has changed to very good.
25/7, yes.
So you'll have to find a way to, let us say, for instance, he is entitled his period for 2016 falls or is covered under two memorandum.
But for that second part also, he had not received. Had he received that, very good. We may have given him very good for the previous year, but
We're not on that. He may have received good. We are not on this. But till 24/7, his good was sufficient to be counted. That he has been deprived of.
no, that we have to this.
You'll have to say that notwithstanding the good up to 24, it is still not sufficient for him to fall within the parameter.
That is why this office memorandum has already 75 said that we have just now I have placed one document, Lordship. This is very clear that prior to good we will accept it as very good, because it should be very good for all the 5 years. But when the benchmark itself is good, we will take it as very good. So up to 24/7 we will take good as very good. But for a later part, he has to actually achieve very good. And that is how others were considered and who have not.
This is again, this is leading to further confusion. If you look into clause number 2, please read clause number 2.
APR grading good for the period prior to 25/7/16, that is the date from which the new benchmark made applicable, may be treated as very good while considering such cases by the screening committee or BOO.
That's right. So from 2016 to 24/7, he is to be treated very good.
Very good. That there are no difficulty. He had actually received good, but we have not rejected his claim on the ground of that. Because good we will take as very good, because at that time that is the benchmark. Problem is for 2016 only.
Then you come to 3.
There should be at least 3 very good grading and other 2 not below good grading out of last 5 APR, considering point number 1 and 2 in view for arriving in the prescribed benchmark very good. So I mean,
So we pause here for a moment. 14 to 16 to 24/7. As per your OM, even if he gets good, you'll treat him as to be very good. As well as up to the all the other periods will be have to be treated as very good. So if that be so, then he satisfies clause number 3.
there should be at least 3 very good grading and other 2 not below good grading.
For the last 5 years.
Yes.
You want some time to reflect? Your OM says very good.
Lordship fix it for hearing.
We are hearing. What else are we doing?
Admission or but this 2016-17 he's has to actually the other cases, other persons are very good in
No, we are
2016.
reading your OM. Your OM says that at least whatever we have understood. Prior to 25/7/16, it is treated to be very good. Then he has got good up to 24/7. So there must be 3 very good. So those good will be deemed to be very good. Because all these are prior to 25/7. And after 25/7, he has got good. Why is he deprived of it? Up I got 20 May.
Lordship.
Clarify of this. Heard counsel for the parties. The dispute between the parties is the dispute heard before the court by the petitioner is denial of his financial upgradation, second financial upgradation, which the petitioner claims is in violation of the guidelines of OM. The respondents have filed their affidavit from justifying the claim to the that in terms of OM dated 21st of February 2018, that goes to the affidavit. The for level 11 and below, the benchmark from 2016-17 onwards has to be very good. Stop. The petitioner falls with the pay scale of level 5.
My lord.
Is it level 5?
Level 5, my lord.
Level 5. And therefore, the benchmark applicable in respect of the petitioner will be good till the benchmark was altered to very good with effect from 25/7/2016.
16.
The respondents have rejected the claim on the ground that for the last 5 years there must be at least that for the year 2016-17, since the benchmark is very good, petitioner was not allotted the benchmark of very good, it was allotted the benchmark good, and thereby he does not right. During the course of the hearing, the respondent surfaced before the court an office dated 10th of January 2016, which reads this under extract. Perusal of this office memorandum showed that for financial upgradation under MHCPS, the prescribed benchmark will be within both very good for all posts with effect from 27/5 of the that apart, for the period prior to 25/7/2016, the APAR rating within bracket good may be treated to be very good within both by this topic. Further, there must be at least 3 very good within both rating and other 2 not below within both good rating out of the last 5 APR. In so far as the present petitioner is concerned, the rating received by the petitioner as is reflected in the
Page 93.
list of persons for grant of financial upgradation. It is seen that the petitioner received the following rating. 2013, I paid good, serially good. 2014, good. 2015, good. 2016, good. 2017, very good. So, his claim for financial upgrade, second financial upgrade, yes, therefore was rejected on the ground that the year 2016 his grading ought to have been both very good instead of good, and thereby he does not meet the benchmark prescribed. However, in view of the OM dated 10th of January 2019, which is produced, it appears that the benchmark of very good was made since the benchmark of very good was made effective from 25/7/2016, and there is no clarity as to how the benchmark received up to 24/7/2016 are reading the OM dated 10th of January 2019, it appears that even the benchmark of within both good received in the APR prior to 25/7/2016 may be treated to be very good by this credit. If that be so, if that interpretation needs to be adopted, then prima facie it appears Maybe entitled to be claimed for petitioner. Correct. And let the respondent counsel direct obtain instruction directly with respect of this particular office member. Therefore, said the court instead of 20, 20. And 8.
I'm obliged.
But the matter may be possible for time being, madam, for time being, madam.
Why?
After we will.
Why timing?
Well, the leading counsel YS Nandan is court number 21, madam.
After we will.
Some other day, Lord. Today it will do it.
Time being
Some other day, Lord.
some other day.
Today it will be little bit difficult, Lord.
Why?
We have some personally. Some other day, Lord. There is no urgency in the matter.
Counsel for the respondent industries department.
And social welfare.
And social welfare
Employment.
will be taken up. Some other date, as a request has been made by the council. Holding of the matter after the time. Is taken. Hello. Okay. Next week,
Next, any date, madam.
any day.
Any date.
Industries and employment.
20. Let it be on 20.
But industries
20.
and employment, madam.
Industries and employment. 20.
Oblige.
Obliged.
Great, Vijay. I have a small player in this matter. So I'm appearing for Indian Oil Corporation in this matter. What has happened is the petitioner was terminated in Indian Oil Corporation because of submission of a fake certificate. Now, the IOCL had verified that on the basis of the communications with the state government, the additional deputy commissioners and the board. Now, the affidavit that has been filed by the state has not been served upon me. So therefore, I'm a bit handicapped as to what is the stand of the government in this case. The affidavit is not with me.
Yeah.
Otherwise, the pleadings are completed, Lordship.
Yes, I will serve you.
The rule, High Court rule, we have to serve.
Ultimately, the dispute is between us, but then that affidavit will be required because it's basing on their communications that we have taken this action. So if affidavit may be served, copy may be served upon me, and date may be fixed, Lordship.
You have already filed your affidavit.
Us, we have filed, Lordship.
Huh?
Our affidavit we have filed.
Huh?
But to argue this matter, I need the affidavit of the state government also.
Have you filed it?
They have
Yes,
filed.
Lordship,
They
we
have
have
filed, a
filed.
copy has not been served.
But it is not here in the court.
It is there, my lord. It starts from page number 108. to 124.
Affidavit filed by respondent 8.
Yes, Lordship.
Manos Jutina, ADC Kodia. Otherwise, the pleadings are completed. Lordship can have it for hearing on any date, but let them serve a copy upon me. Let me take my instructions on that affidavit also from the corporation. Oh, yes.
You serve copy. Copy of the affidavit be filed by the respondent 8 will be served on the council. You have filed your reply.
We have filed that.
Otherwise, the pleading will not be listed for hearing.
File for 5, 6, 7, and 8.
For hearing, the month of June.
Yes, Lord. Oblige, Lord.
No number.
Miss Query is not here.
Where is the Michaels? Michael. You will see a Michael.
D Gogoi.
D Google. We follow up after something.
From the last question, direction and given to the SAT department to obtain instruction who is the.
I've also received an instruction, Lordship. Lordship, kindly peruse. কি হয় যদি হয় মানে প্রথম কি খুব সমস্যা হবে
Yes. What is the meaning of para 2?
Lordship will come to
Para 2 of your instruction.
no, Lordship, the second page, my lord, of the Assam Secretariat's grade 4 and record supplier service rules. Lord, as far as the we've gone through the judgment which on the last occasion the petition had given, but the department, my lord, had said that the appointing authority in my lord in as per the at page 15, my lord, is the irrigation department. And my lord, what has happened is that it should be the deputy secretary of government of Assam in the secretariat administration department should be the appointing authority. In this case, it's the under secretary of a different department, that is irrigation, man. But that is the first thing, man. So my lord, he does not come under our rules because of the fact that he has not been appointed by our this thing. And what has happened, my lord, is that the judgment which they have given that day, that was I think of 2018. Subsequently, my lord, there was an amendment, my lord, that on the last occasion which I had given on 23, the amendment was there, my lord, and I have annexed that again here, my lord, in the third page of today's instructions, my lord, where they have said that, my lord, the Secretariat Subordinate Service Rules 1963 was last amended in 2023 by notification number so and so, dated 27/12/23. And as per this said amendment, Secretariat means all the departments of the government secretariat, the staff of which are appointed, my lord. The appointed by the General Administration, Secretariat Establishment and General Administration Secretariat Nazara Department only against permanent posts of the concerned department, man. So, and that is in that being 23 amendment which has been made, man. His appointment was given by irrigation, not by the SAD.
You are now working as what?
Upendra.
You are working as what?
Grade 4 in the
Grade 4
irrigation
peon.
department.
Huh?
Irrigation department.
In which post?
Grade 4. Grade
Grade
4
4.
peon.
You are asking for what? Regularization.
No. I am already regularized. Regular.
You are asking for promotion. Which post?
Junior assistant or grade 3 lordship. And my lord, interestingly,
Where is the rules, set of rules?
rules lordship, partly I have annexed lordship in page 16 lordship, annex that 2. Page
These are
18.
amendment rules.
Amendment rules lordship in page 19, page 2012, page 20 relevant part, page 3 lordship, page 20 lordship, subsection 3 of the amendment
So
rule.
where are the original rules?
Original rule page 16 lordship. Assam Secretariat Subordinate Service Rule 1963 regarding the promotion part in page 18 lordship.
The page is
Page 18 section 8 lordship, which is the promotion of vacancies to be filled up in.
point out the cater. Cater.
12.
Where is the cater?
Page 20 it is mentioned that lordship. Page 20.
Come page to page 17.
The services reserve notification, upper division, lower division assistant,
Which post are you asking for now?
LDA lordship, lower division assistant.
Lower division.
Assistant.
How is it to be?
Page 20 lordship, this is the
20.
discussion. Page 20, section 3. Page 20, section 3. Lordship, may I read, lordship? By selection from among the grateful staff and record suppliers of the secretariat who possess the degree of university recognized by the government and also
Right.
possess.
Let us ask your DAD give us the rules, complete rules.
My lord, my lord, the last occasion I had given the rules, my lord, the abstract.
Not abstract, give us the rules. What is the name of the rule?
It is the Assam Secretariat. It is the Assam. Assam Secretariat Subordinate Service Rules.
Where are the rules?
It's in the, my lord, the service manual.
Service manual.
Exact similar lordship, just now I have placed a judgment lordship.
That's when we come. We have to understand your fact.
Yes, sir. Another judgment lordship regarding the water resource.
You want a judgment, you type out the judgment, I'll sign it, you get the order, end of story. Why go for a hearing? Which rule?
Assam Secretariat Subordinate Service Rules, 1963.
Not here, I think.
It's not here.
It's not here.
No, it's not here. Only get it.
You get the rules.
My lord, I'm allowed to file an affidavit also, my lord, with this, along with.
What are you doing since 21?
No, my lord, on last occasion, what happened was that when it came up before the other court, my lord, the honorable court had asked me to, what is our stand? On that occasion, my lord, our stand was that we are not the necessary authority.
We want to see your rule.
Fine, I'll get it, man. I'll get it. I'll get it. Fine, I'll get it.
When will you get it?
Lord, Lord, we'll have it day after.
How many
Next week.
Next week. I thought you'll say two of.
No.
Rules are not available in the web portal.
Okay.
No.
It is,
Next week. When you appear before the court, you must be you must study your brief. Anticipate what queries can come.
Apologies, man. I'll get it done.
No, don't offer apologies. Your apologies are not useful for me. 22nd. Yes, some instructions.
Yes, my lord, I have received some instruction, my lord. My lord, after going through the instructions, my lord, I have
come to know, my lord, there are two parts of in this case, my lord. It's admittedly some allegations were received, my lord. The complaints were received, but as the competent authority to punish him, my lord, if any allegations has come, my lord, then it was the only commissioner, not the deputy commissioner or chief executive officer. I have marked one, my lord, tag mark one page, my lord. Through that, my lord, the chief executive officer, my lord, sent the complaints to the commissioner at my lord. But the deputy commissioner, my lord, when the transport were issued, my lord, in between the district, there are no any mention that that was in for receipt of the complaint, my lord.
You have not read the last order.
My lord,
Last order of the court.
record.
You have not read.
My lord, the one original page is there, my
So
lord.
have you read the last order of the court?
Well, actually, the last week, my lord, I have some medical issues. That is why I could
Our
not.
orders are uploaded in the web portal.
My lord, some
What purpose?
I problem I was going through, my lord. I've just received this in the morning, my lord.
Take it back, read the order, and come.
My lord, my lord. But then we fix on the next week, my lord.
We are fixing it day after Thursday.
My lord, tomorrow is a holiday, my lord. The election is.
You just read the order, come back on Thursday.
My lord, my lord.
It's on Thursday. Take instructions in terms of the earlier order. Right?
Well, if possible, Friday, my lord. At least one open day for my office, my lord.
So we are asking you to read the order.
My lord. I love you.
All right, then come on 15.
My lord. 15. My lord. Yeah. I love you.
Yes. My lord, here in this case, the argument has concluded, my lord. On the last occasion, with regard to, my lord, the difference between an acquittal and discharge, my lord. For that purpose, my lord, I have.
We only have to pass the order.
Yes. Yes. That's
Close it then.
Yes.
We'll pass order. Heard. Learn it from. Dispose.
Definitely.
Mr. A.K. Bhuiyan.
Right.
Mr. M. Das Protector. Mr. T. Mazumdar.
Yes, sir.
Senior Advocate Additional AG and M. Bhattacharya. For the state respondents, Mr. C. Purvapur.
Response number 5, Accountant General in 20, item number 26.
Accountant General for item.
I am only assisting lordship, assisting additional agent.
You want,
Yes, sir.
we may not record your name.
Lordship.
Hello.
Yes, what is to be done?
My lord, he has to cross the bar of limitation as I pointed out.
Yes.
And second, my lord, is the power of attorney holder. I have another judgment on the power of attorney holders cannot reduce evidence.
That is correct. No, we are not at this stage.
My lord.
Of evidence will be adduced before the tribunal.
I'm just saying, in fact, if it goes to arbitration,
That's Goa matter. It's from Goa.
no, it's one core, it's total 10, my lord. For the
Your lordship, my submission is that first of all,
First, you will have to answer the question of limitation, whether it is applicable or not.
yeah, it is not applicable because the limitation act starts after payment of final bill, and that is 3 years. And here I am submitting the letters
written by respondent that the final bill has been prepared in 2024. And before that, we already applied for arbitration, and 2 hearing has already been done in the court.
Can this question not be answered by the arbitrator?
Yes,
Example.
yes. But the order he's relying on is of no substance because the High Court is relying on a High Court order, my lord. There is nothing discussed. There's just short leave to apply for arbitration.
Which order?
Perhaps additional affidavit petition given. There's an affidavit by the petitioner.
There's an additional affidavit regarding the judgment. There's 21 and 22 of additional affidavit.
22,
yeah.
21 and 22.
Yeah. 22 where the High Court order.
What relevance is this High Court order?
Your Lordship, first we filed that the cancellation of the contract should be declared illegal. That's why we filed a writ petition. Then the High Court said that there is an arbitration agreement in your contract. So you go for arbitration. After hearing that, we withdraw the writ petition and then we file arbitration petition. That
This
is
is
it.
not a direction. It is at your request that you wanted to approach arbitration. You are allowed to withdraw
Because
the
we
petition.
were told that is maybe I was not there I did not plead in this case, but we were told that there is an arbitration agreement, and if you want to get it, declare
No,
cancellation of contract.
That is what I am trying to convey. That submission for this order will not be a direction.
Anyway, if that is not applicable, then my letter is there. Limitation act start after the payment of final bill 3 years. And in the letter, the respondent has prepared my final bill in 2024.
You referred to one judgment. What is that?
BSNL versus Nortel, my lord.
Nortel.
Nortel, my lord. Section 11.6, read with section 43 and
Which was the
limitation.
paragraph?
Paragraphs, my lord, exactly.
Paragraph number?
Paragraphs, my lord. Paragraph 13.1, my lord, and 13.2. And 14 and 53.1 at last.
And 14?
14. 17, my lords. And relevant is 15. 15, 1-5. And it concludes at 53.53, my lord, they are set of directions. Check nothing. Bill to bonnet. Yeah, नहीं आता ना काम कैंसिल करके क्या हो the payment is to be like cap cancellation is every customer claims drive evidence ना evidence के तो power का नहीं होता है अगर अपना कोई काम ना हो it doesn't happen it evidence depends ना for our back it happens when was the notice issue served notice my lord he issued a notice in the on the 14 February 24 but this is not valid lordship because at that time he was not authorized to issue any such notice the power of attorney was issued only on 5th March 24 the termination was on lordship 20 October 2020 and also the notice was issued under section 11 lordship not under section 21
Your Lordship, in my
intention was to invoke provisions of 11 perhaps.
Your Lordship, in my reply, I said that is a difference of only 2 days. In my reply to I said submitted an authority letter written by the
One
proprietor.
day could be fatal.
It is there, I agree, it was a mistake by the proprietor. It should have been 14. That I agree. But just a technical mistake, I think, should not be so serious that the appointment of arbitrator can be.
There are 19, I think. Yes. 19.
And for
There are 19.
19. Yes, madam. Reasoning in all the judgments, it's well, meaning if that letter is not answered, either an affirmative or positive within 30 days also, limitation runs. That his letter to appoint an arbitrator in the month of 14 February also. But he should have issued that letter within that 3 years, which started from 31/10 or 20 October 2020. And there is another.
Arbitration will
start from your lordship of the payment of final bill.
Section paragraph 20, there's a observation of another judgment. It says when the cause of action arises. Para 20 minutes. Is 3 years from the date on which the cause of action or the claim which is sought to be arbitrated first arises. Cause of action arises in 2020 because it was
20 was the cancellation.
20 was the cancellation.
So prior to that, is there any dispute resolution or anything like that?
Because your lordship, in my letter, we said there is a pending payment against the client, and that is available in my additional affidavit, page number.
Sorry, you are referring to
Page
para
number
20.
30 to 31.
Mr. Gogoi, you are referring to para 20.
20 also.
31, 31, 30 and 31. Against the cancellation, we wrote a letter that there is a pending payment against you, and you have not paid it. The last paragraph, your lordship, page 31. Apart from that, it is submitted and your lordship, the order of it. first area B, you note page 30, column B, the other allied works and page number 30 in our reply.
So, but this judgment,
No, sir.
have you read this judgment? Bharat Sanchar Nigam Limited.
No.
I'll give him a call.
Read it. You read paragraphs 19 and 20, 21. Amongst, you read the whole judgment, but paragraph 19 and 21. What it has that in the absence of any provision, Article 137 will be limitation act. 3 years. The date your cause of action arrives.
Lots of limitation exchange payment of final bill, and our payment has not been made.
Payment has not been made, but you have to take a claim. You have you take your claim only after 4 years. Your final bill is raised when? On the cessation of the contract.
Now that, your lordship, if I would request you to go my additional affidavit. Page number 30. Reply. In my reply to, termination of contract. And there B, the other allied works like repairing of pumps, that was item 20 after cancellation of the contract. In reply, we said the other allied works like repairing of the pumps, cables, fencing, etc. have already been executed on ground to the tune of rupees 12 lakhs, against which first area submitted. The same has not been paid by the department till date. And in fact, the final bill, that first area amount has been converted into final bill after cancellation of the contract.
So this is in 2017, page number 29.
We wrote in 2020, your lordship, after when the contract was cancelled.
Which additional affidavit? Affidavit filed on?
Well, it's an affidavit in reply.
Reply.
To the union mail. Running page is 200.
30 page number.
Affidavit in reply.
Reply.
Yeah.
Page number?
207. There's a letter dated 31/10/2020.
That is our reply in against the cancellation of the contract. And B, where we claim the payment that we have submitted the bill. And due to their failure to pay, this contract was cancelled. So it was not our fault anyway. And this amount has been converted into final bill. In my submission, contractually, they have no right to cancel the contract because they have committed the breach of contract.
What is to be decided in arbitration?
Yeah, that's why.
But we are now on the question of limitation. You had replied on 31/10. So you did not enforce the arbitration clause. You came to the court. Court said
Because risk and cost was tender was floated. So we came for to file a writ petition to stop the cancellation to float the risk and cost tender.
what is your grievance? Your grievance is the termination.
Yes, yes.
Now to find out whether you have any rights or claim, there is a provision for arbitration. You knew that arbitration clause was there.
So please give me, let them available, make me available
Yes,
the
I'll
judgment.
provide.
Give me, I will get the next date and I will reply.
Go through the judgment.
Yes.
Sanjay Sharma, person in the court. Devi, EGC, representing Mr. Portable, you are court?
I'm just assisting.
And the part further hearing. We'll have it in when? June? 5th of June.
5th of
May please. Look, this is a matter pertaining to departmental proceeding. Penalty of reduction of pay by one stage was imposed upon the petitioner. Or the petitioner, he initially joined Air Force on 7/8/1985. Then he retired from Air Force as weapon fitter on 31/8/2005. And he got appointment in SBI as armor. That your lordship will find annexure 2. Yes, the chart. The first they have issued a show cause notice. In fact, one of the main plank of my argument is that there was not even a charge sheet. They initially issued a show cause notice that your lordship will find page 33. So this is a show cause notice. May I read, my lord? You had joined the bank service on 16/4/2008. You were on privilege leave for 9 days from 29/9/2009 to 7/10/2009. You were also granted extraordinary leave for 24 days from 8/10/2009 to 31/10/2009 on medical grounds. You had submitted evidence of suffering from typhoid issued by Community Health Center, Ramnagar, Allahabad, advising you rest for a period from 10/10/2009 to 31/10/2009. But a letter by number so and so, dated 25/3/2014, received from Director General of CISF Block 13 so and so, suggests that you had joined the CISF on 3/10/2009, had been attending training at NISA Hyderabad, had been on the roll of CISF from 3/10/2009 to 11/5/2010, and were released from CISF on 11/5/2010, date of termination. You did not resign from bank service before joining CISF and continued to be in service of two different organizations simultaneously without any information to the bank. It has therefore been decided to initiate disciplinary proceeding against you on the following charges, allegations. Allegation number. No, Milord, this letter, basing Milord, the entire proceeding, whatever the allegations in the charge sheet is was based on this particular letter of 2014, 25/3/2014. It says that I was in employment with CISF or under a training. But this charge has been held to be partly proved by the inquiry officer because there was no material. In fact, this entire allegation, the first part, is totally misconceived, my lord. I was not. In fact, I was doing duty in SBI, which came to be light later on during the course of the inquiry. I was doing duty, my lord. I'll just explain, my lord, what. If your lordships want to see this 25/3/2014 letter, before I go to the allegations, at the very beginning, my lord will kindly see page 35. It says, please refer to your office letter CSO so-and-so seeking service particulars of Sri Gyan Singh. This was, the period was of 2009. This was issued in 2014. Particulars of Sri so-and-so ex-SI EXC of CISF. Lordship will kindly mark it. I was never an employee of CISF, my lord. I was in Air Force. Now, as desired, the relevant information in respect of Sri Gyan Singh X, this is issued by Assistant Commandant Training of CISF. As desired, the relevant information in respect of Sri Gyan Singh, so-and-so is furnished below for necessary action, please. So he has shown that period of NISA training at Hyderabad, 11/5/2010. So I was never employed with CISF. My previous engagement was with Air Force. Number one. Number two, this person who had issued this communication to the bank, he was never called during the inquiry, nor his statements were taken. I was working with, I entered service at Air Force. I retired as weapon fitter in Air Force. This page 37 thing, this is not part of the DP. This was, why this was annexed, I have seen, why this was annexed with the written writ petition by my previous counsel, that I don't know. But this was never submitted. I have checked up the record. Understand. Understand. Understand me. I beg, this was not, if your lordships kindly see page 30. Yes. Page 38, if your lordships kindly see page 38, it was never signed also. So I have got serious. Yes. But one thing I can submit before your lordships. This document was never a part of the inquiry. Yes. Yes. Correct. Correct. Yes, my lord. And during, but this document, my lord, I don't know why this was annexed. I understand, my lord, but this was never a part, neither the inquiry officer nor the. Yes, true. Yes, true. Lordships can take. Lordships can take, but disciplinary authority has not taken any notice of this document, my lord. This was this was never a part of the inquiry also. This was never a part of all the documentary evidence adduced Yes. So that fact has been disproved during the course of the inquiry. The inquiry officer derived conclusion that it is partly proved on a different context, not on this context, my lord. But I have to perhaps disown this document, my lord. My lord, it's a difficult thing for me. But it's true, correct. Your lordships can take a judicial notice of this, but this was never signed, nothing, my lord. No signature is there. Even this was correct. Yes, my lord. But I correct, my lord. My lord, my humble prayer before your lordships would be to just since this document was never considered by the disciplinary authority or the inquiry officer, or it was never a part of any of the document produced during the course of the inquiry, my lord. My humble prayer before your lordships is to just skip these documents, or just to, my lord, he's still employed in SBI, my lord. He's still employed in SBI. Now, if I just take your lordships to the charges again, page 30. Yes, my lord. Not before that, I'll just place one aspect regarding my submission regarding, my lord, that there was no charge sheet. Lordships has seen this show cause notice at page 33. And if your lordships come to page 34, by this show cause notice, the petitioner was granted 15 days time asking as to why disciplinary action should not be initiated against you. Now, if your lordships kindly see the charge sheet, that your lordship will find at page 39. Now, initially, my lord, in the show cause, there were two allegations. Now, in the charge sheet, they have improved and they have 6 charges, 6 purported charges. Although they term this to be a charge sheet, but in my humble submission, my lord, it was not a charge sheet. Because of the fact, if your lordships kindly come to page 41, if your lordships kindly come to page 41, para 3 down below, by this also, the petitioner was given time, 10 days time, to file reply as to why a DP shall not be initiated against him. So, in my humble submission, Miller, there was no charge sheet. No, in my humble submission. Page 41, my lord, will find no statement of allegation, no list of document, no list of witnesses, and from bare reading of page 41, para 3, your lordship will find that this cannot be a charge sheet. It says, with therefore show cause within 10 days from the receipt of this memorandum as to why suitable disciplinary action should not be initiated against you. If you fail to submit reply to this charge sheet stroke show cause notice within so and so, it would be presumed that you have no submission to make. Undersigned shall proceed further accordingly. So it says you submit reply why DP shall not be initiated against you. It doesn't say that under the provisions of so and so, so and so, so and so, following are the misconducts against you or the charges, you filed your reply within so and so. So they presume this show cause notice, which my lord did not contain the required, my lord, as per the procedure, did not fulfill the required procedure, and they proceeded with the departmental inquiry. Now, initially in the first show cause notice that they served, there was only 2 charges. Then they improved upon 6. The first charge remained the same, that you work with the CISF and all, and that your lordship will find page 39. And rest of the charges were with regard to, my lord, going on leave, staying, my lord, claiming 1 day extra bill for as halting allowances, all those things. So in my first plank of argument is that, my lord, this page 39 show cause, it's a show cause only. It cannot be a charge sheet. Now, if you look, the bank's bylaw says that it has to be a charge sheet. And if we go by the any other service rule, if we go by the Assam Service Disciplinary Appeal Rule or CCS CCA rule, it categorically provides that a charge sheet has to contain the statement of imputation. It has to contain the list of documents, list of witnesses. The reason is twofold, my lord. The requirement why this my lord, provision has been made. The disciplinary authority has to give a preliminary opportunity to the charge officer. Look, these are the allegations against you, 1, 2, 3, 4. These are the documents which I am relying on. Till that stage, nothing was affirmed. So you submit your reply. Basing on these allegations, vis-a-vis these documents, you submit your reply. Then the charge officer will submit his reply. Then there is a, my lord, window gets open for the disciplinary authority to take a call whether he will proceed with the inquiry or not. You know, these are settled provision of law. If he wants the no, after considering the written statement, whatever allegations I have leveled doesn't sustain, he can stop there. Thereafter, if he is not satisfied, he'll take a call. All right, these are the allegations. The reply given by the charge officer are not satisfactory. So I will proceed with the inquiry to ascertain the veracity, whether the charges are in fact proved or not, or charges are sustainable or not. Then the inquiry will proceed. Here, my lord, there is nothing. So that vital opportunity that a charge officer gets at the very inception, my lord, that was denied by virtue of this faulty process, my lord. And they construe this to be a charge sheet and proceeded with the entire inquiry. Now, if your lordships kindly consider the allegations at page 39. It provides, while in the service of State Bank of India with effect from so and so, you had taken privileged leave for 9 days from 29/9/2009 to 7/10/2009. Your leave application was silent about the purpose of leave. However, your leave address was stated as so and so, so and so. You had also applied for UL from 8/10/2009 to 31/10/2009, where the reason for leave was stated as I had suffered from typhoid, doctor advised rest, and the leave address was shown as village so and so, so and so, so and so. However, it has been stated in a letter received from the Assistant Commandant Training CISF that you had joined CISF on 3/10/2009 and had been on the roll of CISF from 3/10/2009 to 11/5/2010. Your date of release from CISF, as stated in the letter, is 11/5/2010. It is thus clear that you have made false statement in your leave application and have remained on employment of two organizations concurrently, suppressing the fact of your employment with CISF. So last two lines are basically the allegations, my lord. Now the next charge, although you had been on leave from 29/9/2009 to 7/10/2000, 7/10/2019, 2009, my lord, you have signed as an attendance registrar on 29/9/2019, 2009, 30/9/2009, 1/10/2009, and 3/10/2009. This amount to tampering of records. This is the second allegation. If we, my lord, consider this particular charge, the first charge, my lord, gets disproved because Article 2 charge said that I signed as attendant register on 29/9/2009, 30/9/2009, 1/10/2009, and 3/10/2009. So 3/10/2009 and to 11/5/2010 was the period wherein the first charge contained allegation that I was in CISF. So the Article 2 charge itself disproves the allegations of contained in Article 1. Then the third charge, you had submitted a TA bill on 36/2004, 2014 for visiting some branches under Tura region. In the said TA bill, you have mentioned the date and time of departure from headquarters as 16/6/2014 at 5:30 hours, and the date and timing of returning to headquarters as 26/2014 as at 22:30 hours. You have claimed and been reimbursing with the halting allowance for 5 days from 16/6/2014 to 26/2014 at the rate of rupees 375 per DM. You had absented yourself for the next 8 days, and subsequent to reporting back for duty, you have submitted leave application for 8 days from 21/6/2014 to 28/6/2014. You had submitted along with your leave application a medical certificate issued by NRHM Community Health Center so and so, which was dated 21/6/2014. The sick fit certificate issued on 28/6/2014 by the same authority also mentioned having advised you rest from 21/6/2014 to 28/6/2014. There is no known means of conveyance available from Guwahati, which starting anytime after 22:30 hours on 26/2014 could reach you Ramgarh in Allahabad on 21/6/2014. Logically and logistically, for anyone to reach CHE Ramnagar at Allahabad during OPD hours on 21/6/2014, one must start from Guwahati much earlier than 22:30 hours of 26/2014. It is alleged that you had actually returned to Guwahati on 19/6/2014 and set out on your journey for Allahabad by the next available conveyance. You have given false statement in the TA bill dated 36/2014 for undue monetary benefit of excess halting allowance for 26/2014, on which day you were not on official duty. So in Article 3 charge, the basic allegation after saying so many things was that on 26/2014, you have claimed halting allowance which you were not entitled. Yes, my lord. Page 33, my lord. Yes. 13.5. Yes, my lord. Yes, my lord. Yes, 9/4/2015. 9/4/2015. My lord, because it does not contain the essential ingredient of a charge sheet. The essential ingredients are statement of imputation, list of documents, list of witnesses, and more so, on top of that, your own document at para 41 says, para 41.3 provides that as to why DP shall not be initiated. It doesn't say that by this is a charge sheet, DP has been initiated against you, you submit your written statement within 10-15 days. They don't have rules. One rule is there, my lord, State Bank of Employees. Page number page 4. That is, or you will kindly come rule 68, third page. Yes. Decision to initiate and procedure for disciplinary action. Lordship's got my lord. The disciplinary authority may itself or shall, when so directed by his superior authority, institute disciplinary proceeding against an officer. The disciplinary authority or any authority higher than it may impose any of the penalties in Rule 67 on an officer, provided that where the disciplinary authority is lower in rank than the appointing authority in respect of the category of officers to which the officer. I'm just coming to the relevant. Next page, my lord, will kindly come. Where it is proposed to hold an inquiry, Roman 3, the disciplinary authority shall frame definite and distinct charges on the basis of allegations against the officer and the articles of charges together with statement of the allegations on which they are based, list of documents and witnesses relied on, and as far as possible copies of such documents and statement of witnesses, if any, shall be communicated in writing stroke sent to the officer, who shall be required to submit within such time as may be specified by the disciplinary authority, not exceeding 15 days, or within such extended time as may be granted by the said authority, a written statement of his defense. On receipt of a written statement of the officer, or if no such statement is received within the time specified, an inquiry may be held by the disciplinary authority itself, or if it considers it necessary to do so, appoint under clause Roman 2 an inquiry authority for the purpose, provided that it may not be necessary to hold an inquiry in respect of the article of charge admitted by the officer in his written statement, but it shall also be necessary to record his finding on its such charge. The disciplinary authority shall, where is not it's not required, my lord. Then
Isn't it applicable to this?
No, if on
award stuff. Statement of employees. These are their award stuff. They are governed by this. Award settlement or report matter.
No,
they are governed by this primarily. Punishment is able to impose on this. On the basis of this.
Discipline appeal rule is there. State Bank of India Officer Service Rules 1992. He is an employee of the State Bank.
Fine. But they are treated as award staff, my lord. So they are governed by award staff rules, my lord. It is a separate set of rules, my lord. My lord. And the punishment was given on the award.
This is an award, my lord. Look, I have annexed in the writ petition also. It's there in the writ petition. Award stuff. Okay, award stuff. Yeah.
74 again.
74, yes. 74 of the writ petition.
And this punishment is also imposed on the basis of that, my lord, what the
Final order.
10/4, 2002.
It also provides for issuing a charge sheet. Page 78, my lord. Para 12. An employee against whom disciplinary action is proposed or likely to be taken shall be given a charge sheet clearly setting forth the circumstances appearing against him, and a date shall be fixed for inquiry. Sufficient time be given to him to enable him to prepare and give the explanation, as also to produce any evidence that he may wish to tender in his defense. He shall be permitted to appear before the officer conducting the inquiry to cross-examine any witness on whose evidence the charge rests, and to examine witness and produce other evidence in his defense. He shall also be permitted to be defended. So it also provides for issuing a charge sheet. Here, Miller, no form has been prescribed.
My lord, page 41 also, my lord, page 41 at para 3, my lord. Page 41, para 3, my lord. It is mentioned as charge sheet, my lord.
No, it's mentioned
Please
as
therefore
charge sheet.
show cause within 10 days from this no form, my lord.
Even if we consider this award stuff thing, their bank's own rule that I have produced before your lordship. Not only bank's own rule, all the rules we have, disciplinary appeal rules, we have conceived of a charge sheet which includes these ingredients. No, even then rule prescribed that it has to be a charge sheet. But if your page 41, para 3, it provides
So the charge sheet, my lord, it is clearly mentioned.
no, not provided. They proceeded with the inquiry. That was one part, my lord, violation of natural justice. That is there. But this para 3, when you say in your purported charge sheet or stroke show cause, yes, whatever, my lord, the ingredients of a charge sheet is, my lord, well settled. Any rule, disciplinary appeal rule, if your lordships take Assam Service, CCA, yes. For 15. Yes. Yes. My lord, what I am yes, perversity and all those grounds are there, my lord. My lord, prejudice is like, my lord, that reply I am disowning, my lord. With all you, my lord, I understand, but my lord, what my submission, but even did he really submitted that? Can we get the instruction? My lord, will permit me 1 minute. Page 37. No, whether he submitted it.
I don't have here, my lord. I'll have to find out, my lord.
It's nowhere in the. I have checked up.
But the
My lord,
petitioner
since
they filed
it's,
it, my lord.
it's the since it's the part of my writ petition document, I have checked up the inquiry report, my lord. It did not contain any reference. Nor the yes, absolutely fine. Nor the disciplinary authority took into account that. Yes. Yes, my lord. But may I file an affidavit clarifying this? Otherwise, it will create problem, my lord, for me. Exactly, my lord. Apart from, my lord, one thing is there. This appears to be an admission on the part of the petitioner. Had this, yes, yes, but apparent, yes, 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 true. But if my that argument that I was never employed in CISF, I was in Air Force, is excluded for a moment, even otherwise also the purported certificate issued by the CISF, well, that document cannot be construed as a relevant evidence while ascertaining the veracity of a charge because of Rupsing Negi applying. That person never proved that document during the course of the inquiry. That ground I have taken because the author of that particular document was never produced. No certificate has been taken from him because a document, if you want to rely on as a disciplinary authority, the contents of that document has to be proved. Now, I have asked also that you bring that person for inquiry. They did not bring. So, since you fail to prove that particular document on the test of evidence, on the 37. No. Yes, that's true. If your lordships consider, because with all due respect, my lord, that neither the inquiry officer nor the disciplinary authority considered this to be an admission on my part. Because had it been so, they were not required to go for an inquiry. On the basis of this only, they could have imposed a penalty. But they have went for, but it will always be safer for me to clarify this, my lord, perhaps. For a reduction of pay by one stage. Effect is that I was brought down to a lower pay scale, my lord. I was brought down to a lower pay scale. Yes, my lord. The ultimate effect was that because thereafter examination was held.
He appeared, my lord. But he appeared in the exam. He was allowed, my lord. There was an order from this honorable court, my lord.
Pursuant to
order, he was allowed to appear.
Pursuant to order of this honorable court, I was allowed to appear, but no promotion effected. I could not get the promotion. Promotion to the The result is in seal covered. My lord, if result is in seal cover, if the punishment sustains, I will not get the promotion. My lord, pursuant to directions of this court, my lord, he was allowed to.
There was an order from this court.
My lord, it's in IA, my lord. I'll just place, my lord. Perhaps, perhaps since it was he was allowed to appear pursuant to the direction of the court, so that's why perhaps this honorable court was pleased to direct that keep it, allow him to appear, keep it in seal cover.
My lord. My lord. My lord, there's an issue I would like to point out, my lord. Actually, our stand was that he was overaged, my lord. He was overaged. The petitioner was overaged, my lord. So he cost 45 years, and being a general candidate, he could not appear in the examination. My lord. My lord. My lord. My lord. Not appearing, my lord. He appeared, my lord. Petitioner appeared in the examination, and pursuant to the order, directions of this court, he appeared, and the results have been now kept in seal cover. That is my instruction. Then he will get it, my lord, if he succeeds in this petition, my lord. Because he has already been reduced to 2 ranks, my lord. 2 ranks reduction has been done, my lord. Yes, my lord.
One stage. Page 71, my lord.
What stage?
After promotion, my lord. No. Oh, he reduction in rank one, it's reduction in pay. My lord, it's not reduction in rank, it's reduction pay.
No, my lord.
My lord, my instruction was due to the penalty. I will not be allowed to appear in the examination.
No, my.
Yes.
He has appeared, my
because
lord.
they have.
Our affidavit says, my lord, he was not allowed to appear because he was overaged, my lord. That is in my affidavit, my lord. Then we have filed one additional affidavit which has contained very serious allegations against the petitioner, my lord.
Because I have
my additional affidavit dated 19/7/2017, my lord.
I have annexed the advertisement also, my lord, Annex 16.
My affidavit dated additional affidavit dated 19/7/2017. 19/7/2017.
It's 20. Okay, fine. Seven, eight.
Lord, we'll go to page 2, paragraph 5, my lord. That the deponent begs to state that the petitioner had annexed a copy. Page 2, my lord. Paragraph 5. Affidavit.
Order date. Lord, there was a direction that to keep it in seal cover till the disposal of the writ petition, my lord.
Para 5, my lord. That the deponent begs to state that the petitioner had annexed a copy of the discharge book issued by the Air Force Authority on 31/8/2005 in his name at the time of his discharge from the Air Force, which has been annexed at Annexure 1 to the writ petition. The said discharge book does not match with the one submitted by the petitioner to the bank at the time of joining in the bank. The bank, on noticing the aforesaid discrepancy, requested the Air Force Authority to verify the genuineness of the discharge book submitted by the petitioner to the bank. The Air Force Authority, on verification, informed that the discharge book submitted by the petitioner to the bank is genuine. My lord, that is annexure page 5. Lord, should we go to page 5?
Here I can reply.
This is the discharge book issued by the in the writ petition, my lord. No, this is not genuine, my lord. This is the writ petition. This is the discharge book submitted in the writ petition, my lord. Then in yes, that the deponent begs to state that the petitioner had annexed a copy of the discharge book issued by the Air Force Authority on 31/8/2005 in his name at the time of his discharge from the Air Force, which is annexed as Annexure 1 to the writ petition. That was annexed by the petitioner as Annexure 1 to the writ petition. The said discharge book does not match with the one submitted by the petitioner to the bank at the time of joining in the bank. The bank, on noticing the aforesaid discrepancy, requested the Air Force Authority to verify the genuineness of the discharge book submitted by the petitioner. The Air Force Authority, on verification, informed that the discharge book submitted by the petitioner to the bank is genuine. Now, the Annexure 1, page 5. This is the discharge book submitted by the petitioner in the writ petition, my lord. And if your lordship goes to page 7, that personal particulars, name in full, Gyan Singh, so and so, lordship will see at serial number D, whether scheduled caste, scheduled tribe, OBC. There he has mentioned as SC, scheduled caste. Now, if your lordships come to page 16, which is the one he submitted to the bank, at page 18, if your lordship goes to page 18, there your lordship will find whether scheduled caste, scheduled tribe, OBC. There it is no. So in one service book, he has mentioned as scheduled caste, and in this service book, which the Air Force Authority has certified as genuine, he is mentioned as no. How come he has got two service book, discharge book? The first one is, second one is genuine, my lord. And the one which is annexed in the writ petition is not genuine, my lord, because there he has mentioned he is a scheduled caste. That we verified, my lord. That is why I'm making this affidavit, my lord. The service book annexed by the petitioner in the writ petition has been manipulated so as to show him as a scheduled caste. Of the discharge book submitted by the petitioner to the bank. Yeah. No, bank was this, my lord, page 16, my lord. 18, my lord. My lord. This is with the bank. That is, he is annexed to the writ petition, my lord. Which is annexure 1 in the writ petition, my lord. So how come in one service book he has mentioned as general and he has mentioned he has scheduled caste, my lord? He has filed the writ petition by suppressing the facts, my lord. He has manipulated the discharge book of the Air Force Authority, my lord. It is a serious offense, my lord. We got it verified, my lord. Lordship will come to page 25, my lord. They have given us a mail, my lord. We have written a mail to the Air Force authorities, my lord. This is a copy of the mail, my lord. Dear sir, verification of the service record of air veteran so and so so and so. Refer to the caption subject. We inform you that the above mentioned air veteran was in service of State Bank of India since 2008. A departmental promotion exercise is in progress and Sri Gyan Singh has applied for promotion in the bank in reserve category SC, where as his service record submitted with us certifies as general category. In view of the above, it is requested to verify the discharge book for our official use. Relevant portion of the discharge book submitted during his recommend to the State Bank of India is attached for your ready reference. Kindly so and so, Amarjit Singh, Circle Square. Then to this, the reply has come on the top, my lord. His discharge book is correct and issued as per rule and policy through last unit. Air Force does not maintain the record of the caste. Because he has come before your lordship with a prayer that he is a scheduled caste, my lord. That's why his age has to be relaxed. He has to be allowed to sit in the departmental promotion examination. Because if he is below 45, he will not get a chance to sit for the examination. He has manipulated the service book, my lord, in the writ petition, my lord. And there is a serious offense, my lord.
Look, same document my senior is relying on, page 7, my lord will kindly see. SC.
Yes. This is the one you submitted in the writ petition. But the one issued by the authority, Air Force authority?
No, it's part. It's
No.
the same thing, part 3.
No, well, you see.
Part 3.
You see page 18 of my affidavit.
No, you see kindly page 21 of the writ petition. Part 3.
Yes.
Part 3. Personnel particulars. Yes, my lord. Page 18 my senior is referring to. It's part
Page
3
18.
personnel particulars.
Page 18 of my affidavit, my lord.
Then page 7 of my senior's affidavit.
That is
part
the
3 personnel particulars.
That is the one which you annex in your writ petition.
And if your lordships correspond, page 21.
21 is the one submitted.
I have submitted whatever I have got from the Air Force. Look, these are all signed and it contains due seal, signature, my thumb impression. The one that I have annexed in the writ petition.
But how come the same discharge certificate contain two different information, my lord?
There may be some information, I don't know. But that doesn't mean that I am.
Then, my lord, the petitioner may be directed to submit the original discharge book.
No, I
That
can
will be with
submit,
him.
no problem. But that does not, that will not
Because-
give a leeway to the respondents to allege that I have submitted, I have manipulated the records before the court. It cannot be. If your lordships kindly compares these two documents, it contains
Lordship will
all
see
the
the handwriting.
signatures,
Lordship
thumb
will-
impression, everything. No, this is not a forensic.
No, lordship will see the handwriting also.
Yes.
Lordship will see the handwriting, page 21 and the handwriting also, lordship.
Same handwriting.
No. So it will look at this. Gyan Singh handwriting. That Gyan Singh handwriting.
আপনি এখন ক'ৰ পৰা পালে সেইটো মই নাজানো।
He has given it to the bank.
No, you are getting documents because that letter from CISL.
He has given to the bank at the time of joining, madam. This is the discharge book he submitted to the bank because
I'll file an additional affidavit enclosing clarifying this, my lord. But this is not the issue in the DP. This is not the issue in the DP, but they are saying that I am claiming. Yes, ma'am. Yes, madam. Yes.
my lord, that is what
Examination.
my lord. That is his prayer, my lord.
there will be connection because the departmental examination was also held in the year 2016 and penalty was also imposed in the year 2000. Yes.
Overage. That is what we have said in our affidavit.
Perhaps it was so happen at that point of time, there was a penalty and at the same time examination was going on. And in that context, my lord, there was an IA file that allow me to appear or, my lord, that reason initially we don't know. We thought because of the penalty, we were not debarred. Then the department came up with a stand that I was overreached. So the yes, no, I'm sorry, my lord. Sorry, my lord. It's there in the writ petition. Perhaps he thought the petitioner thought that because of the penalty imposed, he was debarred from. No, some averment is there in the writ petition. My lord. I'll just file করছি এখন written. Para. I'll just. Para 17, my lord. Page 10. I have annexed this e-circular also by which the advertisement was issued. The SBI authority via e-circular letter that so and so is going to hold a written examination for the post of assistant manager security. For the said post, the petitioner is the only person who is qualified amongst the SBI. The said examination is very rarely held, and if the said opportunity is missed by the applicant this time, then he may not get another chance to appear in the examination in his service time, and he may have to retire in the present post itself. Despite repeated requests, the SBI authority has not allowed the petitioner to sit in the ensuing exam, and his name has not been reflected in the list of candidates appearing in the said examination. Both the things have been annexed as annexes 16 and 17. So under that pretext, my lord, the petitioner perhaps made a prayer that he be allowed to appear in the examination. Yes, ma'am. I don't want to clarify with original. To clarify the original. Yes, ma'am. I'll file an additional affidavit or reply to their content. I'll yes. Yes, ma'am. Fine. I'll clarify this, my lord. No. Even I'll satisfy myself and I'll produce the original before your lordship. No affidavit is required. Fine. Discharge certificate. Well, 2 weeks, my lord. Fine. Can there be a date, my lord? Fine. 27. 27. I'll use.
Okay, sir. There is the order lordship to directing the respondent to lordship produce the all appointment letters.
My lord, we were informed that in 2018, some candidates in the same recruitment process had filed a petition, and then records were sent to the senior government advocate's office, my lord. In 2018, we have a letter. After post that, my lord, it is not traceable, those records.
Very lordship. Serious. Yes.
Yes, there's a letter I sent. We'll, uh, we will ask the department to issue a fresh letter to the senior government office, my lord.
Lordship, it was on 27th of January 25. Lordship, 2025. No, Lord. Entire appointment letter. Because basically I have challenged the Lordship appointment of two candidates who have been appointed declaring this petitioner, the OBC category. So on that day, on 27, the court held that Lordship, since all these are
We'll try to get the
positively to court. Let me fix it that after. Let me fix. 20. Positively, they will put it. 2016 loss related appointment of 2016 loss. So the revision of 2023 loss.
I bought it. Forester. Okay.
Wait, please, Lordship. Lordship, Mr. Senior Counsel J.K. Goswami's court number 23. Yeah, yes, Lordship, records has received already. So he is in Lex in court number 23. Kindly after some time. If not possible, kindly grant.
Small matter, my lord, it can be disposed of in short time. I can wait. Yeah, I can wait, my lord.
Yes, Lordship.
18. May it please, your lord. My lord, the petitioners herein have assailed the selection and appointment of the private respondent to the post of ICU technician. The short point involved in this petition is that, my lord, an advertisement is issued for the state post, and subsequently the last date of submission of application form was 28th of February 2022. We have accordingly submitted the application, but the private respondent, they did not have the requisite qualification on 28/2/2022 because they passed their diploma in ICU technician on 7/4/2022. Yes, Dr. Kindly take up the petition. Annexure 3 at page 35. So this advertisement, Lordship will kindly see from the top, serial number 7 from the top on the right hand side, left hand side corner, ICU technician 47 post. And below that, my lord, eligibility criteria again, serial number 7, ICU technician, diploma certificate in ICU technician from a government recognized institute. Down below, my lord, again serial number 7. Yes. My lord, thereafter, a second advertisement was issued at page 37, annexure 4. Page 37. Yes. Actually, under the same department, one health and family welfare department, one health director of medical education. Serial number 16 at page 37. Serial number 16 is ICU technician, 2 posts. Earlier it was 47 plus 2, 49 posts. And again, next page, page 38, the eligibility criteria is given. Serial number 37, ICU technician, HSSLC in science or equivalent with diploma in ICU. 38, next page number. Serial number 37. HSSLC or equivalent with diploma in ICU technician course from a government recognized institute. Now, Lordship will kindly come to page 42 and extra 5. So, at Annexure 5, page 42, is the extension notice, by which the last date was extended up to 28/2/2022. The last 3 lines of that notice is here. The advertisements were issued on, my lord, 7/12/2021 and 10/12/2021. Yes. My lord, last date not given, but at my lord, page at page 36, if you submission of online application starts from last date of submission of the online application. But when it is the last date of submission was not, date was not specified, madam. At page 36 and the left-hand side column, serial number and below age limit, submission of online application starts from last date of submission of online application. So it was not specified.
Lordship, may kindly turn to the page number 118 of the affidavit in opposition filed by the respondent. There the date was given. There is an addendum advertisement by which it was stated to be the online data from 8/2/2022 to 18/2/2022. Thereafter, it was extended 8/2/2022 to 18/2/2022 midnight.
Yes, this is the last section. Annexure 5, page 43. Yeah. Now, Lordship will kindly come to page 51, Annexure 9. So, this is the Srimanta Shankardev University of Health Sciences under Government of Assam. Result of Diploma in Paramedical Sciences examination, January 2022. Now, Lordship will kindly go to the bottom. Lordship will mark the date, 7th April 2022, at the very bottom. Yes. So, it is in respect of the private respondent. Lordship will, serial number 11 is the respondent number 6, Himantri Bora. Then serial number 12 is respondent number 8. Serial number 15 is respondent number 9. Next page, serial number 217 is respondent number 7. So the private respondent cleared the ICU diploma in ICU technician course on 7th of April 2022. And last date was, my lord, 28th of February 2022. So on the last date of submission, they were not qualified for submitting their application, madam. And in between, there is no further extension, madam. There is a gap. So when these private respondents were selected and appointed, we filed this petition, my lord, assailing their selection and appointment. Now, my lord, they have come up with an plea in their counter affidavit that on 5th of April, 2 days prior to declaration of the result. On 5th of April, there was another extension for 2 days only. That cannot be, my lord. The gap has to be filled up. From 28th of February 2022, no extension. It expired, my lord. So it is binding on both the state as well as the applicants, my lord. Yes, I have annexer 1 and 2 colleague. Annexer 1 colleague is my higher secondary in science, and annexer 2 colleague in the diploma we have got. Annexer 1 colleague starts at page 22, my lord. These are the HSSLC pass certificates in science of all the petitioners. And Annexer 2 college starts at page 28. These are our diploma in ICU technician. We have cleared in April 2021, 1 year ahead. So we are eligible, that is not in dispute. Now Lordship has to decide whether the 5th of April. Yes. No, my lord, at page 28, it's a pass certificate, my lord. Yes. So April 21, exam was held and we passed in December in 2021. Much ahead of the last date of submission of the application. Yes. Not correct. And Lordship, if you got, there are 6 government funds. There are 7 petitioners. And Lordship may permit me to place 2 judgments wherein yes, the Honorable Supreme Court says that my lord record will repeat my paper from the mark.
I am for the private estimate 7 to 10. Initially, there were 4 advertisements of various group 3 posts, including 49 posts of ICU technician, and they were subsequently clubbed into a single recruitment process, and the recruitment process took place. In that process, the initial these advertisement, the date was extended up to 28/2/2022. Thereafter, subsequently, in view of the enhancement of post, another advertisement was issued, whereby it was extended. Again, it was issued on extension was given. Notice was issued that whereby it is stated that this is to inform of all concerned that the government of Assam has newly created different grade 3 and grade 4 posts in Dhubri Medical College, Dhubri. In view of the total number, in view of this, the total number of the posts which were already advertised by this directorate advertisement have been increased. In this context, the interested candidates may now apply online through the links which will be available in the directorate website, that is from 5/4/2022 to 7/4/2022. Candidates who have already applied online for the post against the advertisement mentioned above need not apply again. Their candidature will be automatically included in for these additional posts. Any alteration modification in the application form submitted earlier is not allowed. The revised list of the posts shall be available in the official website of such and such. This was published in the newspaper. And now this has not been challenged before in this writ petition. And we applied on 7/4 because our result was declared on that day. Yes, on that day, because the site was open till midnight of 7/4/2022, we have applied on that date. Because there was delay in the result, so ultimately it was declared and we became eligible as such, we have applied. So, Lordship, there are preliminary objections from my side in this case. Firstly, Lordship, because Lordship, No, preliminary objection regarding the maintainability of the reputation, because that was, no, because these selected candidates, these are the failed candidates, they cannot, they are stopped from, they are stopped. Yes,
So
Lordship.
finally, under the hearing column, my lord.
Hearing column. Because entire, because earlier
Lordship, this
I
is the
tried to
order.
raise this objection. There, and Lordship will kindly see the prayer, the first prayer. What is their first prayer?
Lordship, there is an order of this phone, my lord. Lordship will kindly see. The last three paragraphs.
Lordship, actually on the last occasion, the interim was vacated, so further time was not granted. It was till last date, it was in the admission column. Interim, they have got an interim order in between, and that was vacated. So this was taken up today.
The last three paragraphs of that order, my lord. Last page.
These objections, Lordship, the first of all, Lordship, the prayer. What the writ petitioner has prayed in the writ petition. Yes, Lord. Yes. Yes, Lord. I don't think you.
If necessary, Lordship will produce the record. If necessary, we will produce the record.
Yes, that is it.
Yes.
I brought it up.
Last extension was notice is we have annexed it. That 1/4/22. Our affidavit 161 annexure A. Lordship has got it. I am reading it, Lordship. This is filed by response. Yes, Lordship. That notice clarifies that this is for information of all concerned that Government of Assam has newly created different grade 3 and grade 4 post of Dhubri Medical College, Dhubri. In view of this, the total number of posts which were already advertised by this directorate advertisement number dated 10/12/21 in the Assam Tribune, addendum advertisement dated 8/2/22, an advertisement number so and so dated 24/2/22 have 24/2/22 dated 26/2/22 have increased. In this context, interested candidate may now apply online through the links which will be available in this directorate website, and candidates who have already applied online for the post against the advertisement mentioned above need not apply again. Their candidature will be automatically included for this additional post. Any alteration modifications in application form submitted
Earlier is not allowed.
Yes, my lord. My lord, in the extension notice, it is clearly written. But we will kindly turn to the extension notice because otherwise here it is little bit small, letters are small, my lord. Extension notice are advertised in numbers of them. Yes. Yes. Yes, my lord. 22657 DME. Yes, my lord.
Give me. Wait.
It's not written here, ma'am. So, then this extension notice will not be applicable to this advertisement, ma'am. Here they are giving the Jana Sanjog number, which is usually on the bottom of the advertisement matter.
Donasanto plus D plus 11153 plus 21 dated 10/12/21. From the notice lordship, annexure A of my affidavit.
Lordship,
Got it?
second book. It's a
Cannot
very
read.
tiny one. So in the
Cannot
advertisement,
read.
but that this notice, extension notice, which was issued on and by which it was extended up to 7/4, it has referred about the extension notice, earlier extension notice also. Lordship, advertisement numbers are there, but it is very tiny one. In my affidavit, I have annexed the advertisement number. Yes, Lordship. Affidavit filed by the respondent number 7 to 10. Lordship, page number, it starts from page number 104.
এটা জনসংযোগ যেটা দেখানো পড়ে।
This Janak Sanjog cannot be read because it is very tiny. It is in page 106. The Janak Sanjog number is at the top.
At the bottom, not top.
Top of the Then in the other, I read the same with a magnifying glass only. But Lordship, that is regarding this, may I submit? Because there was initially it was extended up to initially 28 to 2022. In this advertisement, subsequent extension, this advertisement has been pointed out. Extension notice, extension notice dated 18 to 2022. Extension notice dated
Extended 18 to 22, then extended 28 to 22.
Extended to data has been referred.
Then it was 7/4/20. Further extended.
Lordship, in the last extension notice, it is mentioned the earlier Janasanjog number of the earlier extension notice. Extension notice by which it was extended up to 28 to 2022 midnight was the Janasanjog number is D/15755/2021. And in the last extension that is given on from 5/4/2022 to 7/4/2022, this Janasanjog number has also been referred. Janasanjog number D/15775/21 dated 18 to 2022. So this is the continuation of the process. That has been referred. And it was published in the Assam Tribune also.
No.
Lordship,
The
what they are
gap.
saying, they have not challenged this extension.
The gap, my lord, from 28 to 2022, where is the further extension till 1/4? All of a sudden, this we cannot wake up and extend it, my lord. Yes, I have read it.
It is clearly mentioned here.
Yes. 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 They have done so. But where is the bridge between 28 to 2022 to 1/4?
Whether
That
they have
cannot
not
be deemed, my lord. There has to be in writing. That cannot be, my lord. One. Yes, those facts are not disputed. So see, we are on a very narrow point. So will kindly see. First extension was up to 28 to 2022. No, it can be. In my humble submission, it can be, my lord. It has to be. It ought to have been extended from time to time. All of a sudden, it could not be. Next, my lord. Yes.
1/4.
Yeah. 1/4. But my lord, very. True, my lord. Subsequently, they have now brought in on record. But my lord, in between, there is no extension. It has elapsed, my lord. Yes. My lord, in my humble submission, my lord, they have suddenly woke up and just to accommodate the private respondent, they have extended.
No, Lord.
Yes. Yes, there is a gap, my lord. Apparently, there is a gap.
They have. I'll produce the record next date.
And my lord, my humble submission, yes, lordship will kindly pay it. My humble submission before your lordship would be, first, I have already stated, my lord, they have not continued their extension. All of a sudden, they have protected. Next, my lord, the reason given in the last extension, that 1/4, they say number of posts have increased. So that is not anticipated vacancy. That is a future vacancy. That cannot be clubbed in because already posts have been advertised.
They participated in the process.
Already.
Yes, I
when they were
reply.
declared,
But
result
if-
was declared.
True, but here if the illegality is glaring on the face of it, lordship can certainly take note of it, my lord. It's an anticipated vacancy. It's not an anticipated vacancy. It's a future vacancy, so it cannot be clubbed. Next, my lord. Yes. True, my lord. That is true, my lord. Yes. Number one. Absolutely, my lord. I will. True. Next, my lord, my third limb of argument would be in the extension notice of 1/4, they say the number of posts has increased. I have shown 49. Now say the number of posts have increased. Now if the Lordship will kindly see the select list, only 37 has been selected. Where are the entire post may not be filled up? But it was available. We are also there, my lord. Exactly. Exactly.
That notice they have not challenged, Lordship, in the prayer.
How can I tell?
1/4/22. Lordship, I'll produce the report. Lordship may. Lord. Record is necessary.
Lordship, first of all, they are now raising this objection about the extension. When they are raising, that is initially there was a written examination, and thereafter there was a skill test. And the result of the skill test and written examination was declared on 10/5/2023 by Annexer 8. This Annexer, they did not challenge at that point of time. After this result was declared, when they became unsuccessful, they participated in the entire process without any objection, because that extension was not objected to. Lordship, they did not. No, that is the objection. Yes, Lordship. That is the first objection. That, and the necessary part is that because they have what they have prayed for, that cancellation of the entire appointment order dated 25/3/2023, 25/5/2023. In that appointment order, there are several other candidates who were appointed. They were not made parties here. The first prayer is that certiorari shall not be issued to set aside and quash the impugned order bearing number such and such dated 25/5/2023 issued by the Director of Health Service. Entire select list, the appointment order, they want to, by that order, several other persons were also appointed. They were not made party. And this, the select list by which yes, Lordship. Yes, Lordship. Because we oppose. No, because yes, Lord. And being failed candidate, they have select. Yes, Lord. Yes.
On 15th, Lordship. Yes.
I have stated and
Preparing for private respondent 6, my lord. My lord,
May.
15th May I have. Yeah. Any date, my lord. Yes, yes.
One humble prayer. And there was a stay and there was a stay vacation application. There I have filed my response. That response may be treated as my reply in the same thing, same grounds were asked. I have been disposed of by that.
Disposed of.
And other same argument, same pleading, that's why treatment. It's disposed of. deeply.
May I please? In this case, my lord, one prisoner was or detained was escaped from jail in a particular night. On that night, my lord, at least 5 persons were engaged as jail warder. Although 5 persons were there, they were not asked to show cause. Only the petitioner was asked to show cause, and ultimately punishment was awarded against him. The proceeding against the petitioner was not properly processed, my lord. Lord, I have prepared a list of deaths, my lord. It is not provided, my lord. They have admitted, my lord, and no inquiry report, list of death, and
Lordship, in that count, Lordship, the punishment was like,
my lord, report. If you
yes, I have the report, Lordship.
and extra 10, my lord.
It is uh, Rule 7, Lordship. Rule 7, sub-rule 2, Lordship. The punishment was made. Yes, Lordship. Withholding increment of promotion, Lordship. The minor punishment, Lordship. Rule 7, Lordship, sub-rule Roman 2. Yes. Rule 7, Lordship, it deals with a punishment, Lordship. And sub-rule 2, Lordship, is a withholding of increment of promotion, Lordship. Nature of. And Rule 11, Lordship, it is minor punishment. If the disciplinary authority having regard to its findings on the charge is of the opinion that any of the punishment penalties specified in clause 1, 2, 3 of Rule 7 should be imposed, it shall pass appropriate order, and in every case in which it is necessary to consult the commissioner, shall do so after consulting the court. In major punishment, Lordship, it is defined under Rule 10, Lordship, wherein it is categorically stated in Rule 10, Lordship, major punishment, wherein, Lordship, it is categorically stated if the disciplinary authority having regards to its findings of the charge and on the basis of the evidence and adduced during the inquiry is of the opinion that any of the penalties specified in clause 4 to 7 of the rule 7 shall be imposed on the government servant. It shall make an order imposing such penalties, and it shall not be necessary to give the government servant any opportunity of making representation on the penalty purpose to be imposed. Representation is necessary for major punishment. The minor punishment, no such requirement is there. Yes, imposed lordship, two increment lordship. It is one increment lordship. Is a minor punishment as per rule 7 sub rule Roman 2. 12A, nothing, not outstanding anything contained in rule, it shall not be necessary to follow the procedure laid down in the proceeding sub-rules in cases where it appears to be authority competent to impose the penalties at the initial stage of the proceeding, that the penalties of censure would be adequate, but if any later stage it is proposed to impose any other penalty specified in Rule 7 of the procedure laid down in the said rule shall be followed. No order impose the penalty shall, however, be passed except Lordship. 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 Yes. Increment. Yes.
Can accept 5 minutes. Can accept 5. Page 29. But they have violated the provision of Rule 9. And it is admitted by them in their affidavit that list of documents and list of witnesses were not supplied. And evidently, inquiry report was not supplied initially. Yes, ma'am. Lord, may I read the inquiry report first, my lord? Inquiry report reveals everything, ma'am. Yes. Yes, my lord, it was not raised, my lord. But my submission is that as per Rule 9, they are to supply those things. But admittedly, it was not supplied to the petitioner. No, I have not raised that question, my lord. My lord, inquiry report will reveal everything, my lord. There were at least 5 persons. They were engaged without any specific time. And ultimately, it was assumed that the petitioner was responsible for the escape of that detainee without specifying any time. Nobody could say that at what time a person was escaped. No, not only me, my lord, other persons were also there. No, from inquiry report, it reveals everything. So certain specified persons were questioned.
Para 9, page 62 of my affidavit. This point has retaliated. 62, Lordship. Paragraph 9. That in regards to the statement made in the paragraph 10 of the writ petition, and the answering deponent stated that all the duty wardens of the quarantine ward up to 2-27 AM reported that were in order. Sri Gajendra Kolita, warder, took charge from Sri Madhav Deka, warder, at 2-27 AM on 22/10/2021. Also reported to Sri Samudra Kolita, head warden, after he was satisfied that there was no abnormality inside the quarantine ward. As such, taking action against the Madhav Deka warder does not arise, Lordship. He took charge after satisfied that everything is in order, Lordship.
My lord, may I point one thing, my lord? There is only one hole in the door. It could not be opened. Yes. No, procedure was not followed. Rule 9 was not followed. Rule 9,
Yes.
my lord. Sub Rule 2. Last paragraph. At the time of delivering the charges, the discipline authority shall invariably furnish to the government servant a list of documents and witnesses by which this article of charge is proposed to be sustained. So that is mandatory, man. But they are in their affidavit at
Page 62, paragraphs 11, Lordship. Page 62 started from paragraphs 11, Lordship.
Page 63 is 11, my page 63 of paragraph 11. My
yes, sir.
Paragraph 11. That as regards the statement made in paragraph number 12 of the writ petition and the answering deponent states that the statement of allegation was issued to the warder along with the so-called notice so and so of the Deputy Inspector General of Prison, Guwahati. But the list of witnesses, list of documents could not be provided to the warder due to vulnerability of guarding staff from the security point of view.
Lordship, basically the witnesses are the UTP, Lordship. those the witnesses are under trial prisoner, Lordship.
Next
They-
paragraph is also important. Paragraph
Page 30.
next paragraph. Connector 9, page 40.
Yes. Yes, Lordship. These are the listed witnesses, Lordship. Yes, Lordship. Yes, Lordship. It is a UTP. Yes, Lordship. Because, Lordship, the list, Lordship, other, Lordship, in the list of the next statement of list.
Page 42 reveals that there were 5 persons who just in a specified time. 5 persons were whose means, my lord. Yes. Yes, my lord. But one person was not examined among these, my lord. One person was
He was released on bail. UTP one, another UTP was there. Huh? UTP officer.
one person, that is Dilip Boishaw. He was ordered from locking to 8 p.m. So he was not examined. No, my lord. They were officers.
No, not it.
In one night, 5 persons were engaged for different times. And ultimately, responsibility was taken upon the petitioner.
Dilip Basu was examined, Lordship. From the record, it reveals that Dilip Basu was examined. Lordship, moreover, Lordship, from the record, it appears that, Lordship, the statement of the delinquent, the petitioner, Lordship, he categorically stated that was all were in order in the quarantine ward on the top of the office administrative building, Lordship. He stated yes. After when he took charge from the predecessors, Lordship, he satisfied that all are in accordance to the order, Lordship. Yeah. It is in the record, Lordship. My record is there. It is there. Yes, Lordship. The position of the delinquent employee, Lordship, it is a petitioner. Yes, Lordship. Lordship, it is for page 43, Lordship. Page 43. Lordship. Lordship. At the time of taking over the charge by the Gajendra Kolita warden, it was his duty to see far as possible every nook and corner of the quarantine ward through the available holes in the door. It may be mentioned that the inside of the quarantine wards and the ventilator in the quarantine ward can be viewed through the holes in the door. Had the incident occurs before Sri Gajendra Kolita took charge, it should have been detected at the time of taking over charge by him. He should have noticed the displaced rod in the ventilator. So it is assumed that the Gajendra Kumar Kolita either did not check the inside of the quarantine ward properly, or the lapse did did not occur before Gajendra Kolita took charge. It was informed by the it is categorically different. Yes, Lord. It is a central jail, Lordship. Yes, Lordship.
So it is assumed, my lord. Assumption, my. It is assumed that Sri Gajendra Kolita either did not check the inside of the quarantine ward properly. On the basis of assumption only.
No, this is not the, this is the finding is not the based on assumption, but the petitioner was not properly did his duty, Lordship. His negligence was there. Before taking charge, Lordship, he should have the he should got the satisfaction that whether everything is in order, Lordship. Yes, Lordship. What is the procedure, Lordship? When a shift change, Lordship. Yes, Lordship.
Yes.
Yes. We have yes, there have some holes, Lordship. Lordship, and from that holes, Lordship, and overall views comes, Lordship. It is the Lordship. No.
Last.
Lordship. Lordship. Censored.
My lord.
Lordship.
That may be fixed, my. 15. Even in my case of minor punishment, they are to follow it. Even in case of minor punishment, also they are bound to follow the procedure.
But from the Lordship,
Must be.
Lordship.
Lordship, 2 or 3 judgments I want to rely on your Lordship. That your Lordship can go through your Lordship. Just 1-2 paragraphs. Your Lordship. Lord. Lord. Or otherwise, I will do one thing. I will prepare a short synopsis of my argument along with the judgment. Lord. Lord.